JP, Section 905, a draft of Section 905 Service Areas and Assessment Districts was handed out. What is this? Where's the...
This
Where
is
did it come from?
this is my proposal for handling service areas, assessment districts, and taxes. That is my proposal.
Fine, Mary, I didn't...
I'm wanting comments.
Good.
And we will be considering this for adoption along with the finance articles a week from tomorrow. So we have a week to get
Offers
input and...
possible changes.
Okay, fine. I didn't know what I had to deal with right now.
I'm just trying to tell you what it is.
Great.
It's only suggestions. Came from me. I have had input from a great number of other people, and I want more.
Am I now?
And it's only coming from me. This has not been passed by the commission in any form.
Now I'll turn the meeting over to Sherry for report on preamble and A.
We have on the agenda tonight 3 new business items, and these are things which either have been already discussed in the case of B and C, or no, excuse me, in the case of C, or as in the case of A and B, are probably short enough that we can both discuss and adopt them in this one evening. Scheduled under reports is a beginning discussion of finance. Let's begin with a discussion of the preamble, and I must apologize. Rick, who is late, has the drafted copies for all of you of the other things, and so we're a little bit hung up until he arrives with the final drafts. He was going to rework some of the words.
What, do you have the language of the preamble?
Well, you were handed out, if you have your past materials, his suggested wording of the preamble at the meeting when we did the planning item. So it would be along with the name and boundaries, Article 1, and that much we can do without him. Now, I also have, what I had asked the commission to do was to come up with their own version of a preamble for tonight, because it's kind of a personal thing. I have Arliss's version with me. I have my version. I'm not entirely happy with Rick's version or my version. I think Arliss's version is probably better.
Read it to us.
Arliss says, "We, the people of Anchorage, grateful for the privileges and mindful of the responsibilities which we are assuming under home rule provisions of the Constitution of the State of Alaska, and in order to provide responsive local government, do ordain and establish this charter for Anchorage." It is quite similar. What it is a combination of the city and rural charters. Okay. Mine was, and I like the ideas in mine, but I don't like, it's not parallel construction. "We, the people of Anchorage, in order to ensure a community which provides a high quality of life for its citizens, recognizing that we are a community of varying needs and desires, and in order to provide a responsive and effective government, hereby establish this charter." Now, the one that Rick gave you, do most of you have a copy of that one?
We, the people of Anchorage, in order to secure maximum, now, was he meaning to add, or did he take that out? Secure maximum local control of local affairs.
To reduce waste and duplication in government services.
And to secure the most effective governmental response to the diverse needs of this area, do ordain this charter.
The underline means it's new material.
Yeah.
Read it again.
Because we're not grateful.
We, the people of Anchorage, in order to secure maximum local control of local affairs, to reduce waste and duplication in government services, and to secure the most effective governmental response to the diverse needs of this area, do ordain this charter.
A little wordy. Yeah. But the thought is correct.
That business about
Do you have any more
retaining the,
No,
to the people,
this is the one we got
that part will go.
a couple weeks ago.
Could I ask if there's a copy machine here? Is it
It's
available?
locked.
I'm sure it's
Locked
locked
on.
up.
Could you check and see if we could have it available to us?
in the
future
future.
evenings.
I'm sure we couldn't.
I'm sure you didn't want
I'm
one.
almost, it's
No.
one of those great big huge ones and they'd be absolutely
They
panicked.
have plugins on it, and
Autotrons
it is monitored extremely closely.
Well, why, do you all have a copy of the 71 charter here? Now that's a very short preamble, and we could use that and just strike out area, because I would suggest that we say Anchorage instead of the Anchorage area. So we could say, we the people of Anchorage, in order to form a more responsive and effective government, and in recognition of our common goals, hereby establish this charter.
No, that's not bad.
Now, that's really not bad, and the only thing that I would interject in that is that in addition to having common goals, there is some diversity that the charter must recognize, or is recognizing, and that we might wish to speak to that, or maybe not.
Well, gosh, you can belabor this thing all, right through the night with this should be in and that should be in. And really, you're getting a couple of points. Effective government, common goals, and you're establishing a charter to do these two things. Isn't that all encompassing, really? An effective government
Looks like it to me as
and common goals. That's the good life that you look for and all this
Short,
stuff.
I think it's fairly, I don't see anything wrong with the 71 one.
No, I don't. I think that's all encompassing.
Well, I have no real quarrel with that. I'm not particularly grateful for the privileges and mindful of
No one's grateful.
responsibilities.
I mean, that's window dressing. It's just wasting a lot of people's time when you say you're grateful.
National holiday.
Ever the people are whizzed off about things anyhow. They're not grateful. They should be.
How do you feel about saying just, we the people of Anchorage?
Yeah, I'm never grateful.
Fred, we've noticed that about you.
Yeah.
How do you feel about saying, we the
don't
people
need
of
the area.
Anchorage instead of the Anchorage area?
Yeah, I'll take that out. We the people of Anchorage, because you are unified now. It's in Anchorage. We the people of Anchorage, in order to form a more responsive government.
Not effective?
Responsive and effective.
And effective, which means if it's effective, you have no duplication in it. You're supposed to have economies within that government. In recognition of our common goals, your common goal is to live and not get a
Then I
ticket
would-
from state troopers and things of that sort.
I would,
Diverse backgrounds and common goals.
well,
I got to straighten up that state trooper business. I noticed they give summons out without signing them. Did you know that?
I have
When they
very
hand you
limited
it's signed.
experience.
That's right. That's a subpoena. That's supposed to be signed.
They sign it when they sign the copy they turn in.
That's no good. Isn't a subpoena supposed to be signed?
I do believe, Fred, that we're digressing a
I'm
bit,
sorry.
and we have a heavy agenda tonight.
I'm sorry, but I want to talk to the lawyer about subpoenas should be signed.
I would propose then, or I would move, I guess, that we adopt the preamble from the 71 charter, deleting the words the and area.
Second.
Been moved and seconded. There is any further discussion?
Deleting the
I
words,
think that somehow we have to accepting our diversities and recognizing our common goals.
I like that.
I want to get in the fact that we are diverse. We don't just have a common goal. We are diverse. Accepting our diversities and recognizing our common goals.
it's a confusing term. What do you mean by diversity? Somebody reading that code. What is it? What are we diverse in?
You're an individual and I'm an individual. We sure as hell aren't the same sort of people.
No, but we're going to conform to whatever government's laid on us.
But we're recognizing in this government the possibility for diversities better than others, we hope. We aren't trying to make everybody conform. If you get across the idea that this unification is to make everybody conform, you're going to get the major portion of the folks out my way voting against it.
Dick, you've been scribbling away.
Yeah.
Well,
You got one.
Go ahead.
what I was going to say is conform in the sense that the majority is going to have to rule, and the folks out your way are going to be up the creek if they don't like it. I mean, you got to go by the majority. Now, just like I represent the folks out in Ocean View and all those places, but by God,
All right.
I'm talking a unified thing, and I'm not talking Ocean View. So it's got to be by the majority.
I haven't said otherwise.
Yeah, I'll read one, okay?
All right.
It's basically taking bricks, but
But I
Shortening.
think that if we mention this in here,
You say something.
we, the people of Anchorage, in order to secure maximum local self-determination and the most responsive and effective government response to our diverse needs, do ordain this charter.
No.
Responsive response.
It's redundant.
Yeah, it is.
Here,
I go back to the motion. I still like that one.
Mr. Chairman, is there one way of doing this that would say that in recognition that common goals can, and I don't want to make this wordy either, but that the attainment of common goals can be achieved consistent with individual rights or something of this sort? Does that get towards what Mary
that's
is?
coming around toward it a little bit, Joe.
Why do you have to say that?
Because there are a lot of people who may not read beyond the preamble and...
That's right.
Well, if they don't, all right, now.
Yeah, and if they read that, and
If they read that-
nothing else, and it says that, they'll be happy.
Now, what is diversity?
This is what I'm trying to get.
Now, this is what the libertarians, I think, at in charter commission
It's not everybody's the same.
understood.
Well, that's an understood fact. You don't have to insult somebody by telling them that.
You're not insulting them.
does anybody wish to?
All you're doing in the
Or
charter,
does anybody?
you're not analyzing people, you're setting up a government, and you're setting up goals.
Mr. Chairman, we've got 8 conversations going on.
Maybe
That's
people
pretty
will
hard.
see diverse and they will think that, their government will look and see it.
That's dreaming.
Well,
He doesn't want them to
just
see
be
it.
the people of Anchorage in order to form a more responsible, effective government. Right. You're right.
I was wondering about a copy of the draft.
Well, we seem to all be missing them.
It's not a we don't have a draft, so...
No, we don't.
Of the preamble in Article 1?
Yeah.
These were handed out several weeks ago, and I've noticed that people have been coming to meetings with less and less and less of
That's
their
true.
of their paraphernalia, and we can't.
Well, you got me something now. If you put holes in everything you give me, I'll be in business.
I'm sorry.
And if you'll give me all the same sizes of papers,
Everything
I'll be in
except for 11.
business.
Yeah.
No lawyer,
Break over the regular.
old lawyer style stuff. New lawyers
We
usually...
have a motion on the floor, and let's
Chairman?
address the motion.
Could I address the motion, please? And speaking against it, the word effective in the preamble bothers me, and it always has bothered me. I think that's one of the reasons that the last charter was defeated, is that people don't necessarily, they associate effectiveness with, they don't want the government to be that effective necessarily.
What about a more
Now,
responsible,
that's not a desirable.
reasonable? What a more responsible and reasonable government?
No, it's,
Just strike
Jerry?
it effective.
I would propose an amendment. Okay. I would propose to delete "and effective."
Second,
And, wait a minute, and insert following "of." So it would read, "and in recognition of our varying needs and desires," and someone can maybe come up with better words, "and our common goals." If someone can
Is
tell
your
me.
second,
let's take care of one piece at a time.
Okay.
Let's take care of one piece at a time, Sherry.
Jim?
Okay, I'll split that
Of the
and
original one.
first of all say that I move to amend it by striking "and effective." So we have
Second.
just a more responsive government.
But not effective.
Well,
Okay.
if it's responsive, it probably is effective.
That one I read it first.
Okay, go ahead. And then what?
Does your,
That's all she's, let's vote on that.
Sherry, does
That's-
your second accept that change in the motion or after?
Well, you see, my second spoke up before I did the second half.
Let's divide it, it's just too bad.
I second the motion to strike terms and
Okay, I now have 3 seconds. Shall we vote on it?
terms of...
Question. Call for the question.
Mr. Chairman.
All those in favor?
Mr. Chairman, I have something to say about the motion.
Question.
Oh, I think everyone has an opportunity to talk on the motion.
Oh, have you something to say on the amendment?
Yes, I do. Yeah, I would like to substitute, and also move, substitute, when striking and effective, substitute local self.
Local left.
Local self. Form a more responsive local self-government instead of responsive and effective. I think that's getting closer to what we're attempting to do.
No second, sir.
No, wait a minute, is that a motion you've got?
That's an
You
amendment.
amended your motion.
There's an
He offered to
amendment motion. He
substitute.
wishes to substitute for the amendment, by adding the local self in place of.
I'd like to speak to that.
Then make a procedural
Is
suggestion.
there a second on this?
Sure,
Mr. Chairman, I would suggest, this is a very difficult thing to handle in this way because Mrs. Holmes has moved to strike some terms and now we're getting a motion to add. Would it be agreeable if we voted on her motion to strike and then the sentence would be open to additions like yours? I think we can,
Which makes sense.
Sure.
It makes sense.
Sure, no problem to me.
Keep track of what's
All right, if there's no further discussion, all those in favor of the amendment to the original motion, striking
Aye.
and effective, and wasn't adding,
No, not adding.
not adding.
Just striking. Strike.
Right.
All those in favor?
Aye.
Opposed? So ordered. Now,
Mr. Chairman?
do you wish to address the main motion, or do you wish to pursue
Pursue.
another amendment?
Mr. Fisher has his amendment then.
Yeah, Mr. Chairman, this seems like a piecemeal way of going at this, and I'm not entirely comfortable with, and in recognition of our common goals, and I'd like to, I think that everyone is trying to get at something in terms of being slightly diverse, and I think that's not necessarily the proper term, and I'm not artful in writing, and I don't know that it's up to me to do it, but perhaps I could ask Rick if he has any suggestions on this. You weren't here, Rick, for part of the discussion. But, the problem is in recognition of our common goals, yes, that's true, that's why we're doing it, but yet our individual common goals, that's what we need. I think that's...
The common goals are not individual.
No, they're not. The common, to everybody.
The terms are...
Well, our individual goals, how's that?
Individual goals might be one thing in common, then they're not common.
They're
Well,
not
I say I'm
common.
not artful in this, but I understand what people are trying to get at, and I
How
think
about
it's
our
a good
community
point.
goals?
What's wrong with the
Mr.
one?
Chairman, everybody, are you...
That's all, really. I don't have...
Is there further discussion on the...
Yes, I'll try one on myself.
All right.
To say, we the people of Anchorage, in order to form a more responsive self-government and to achieve common goals while respecting individual rights, hereby establish this charter.
Would you get
To achieve,
portion past achieved to be into that?
And to achieve common goals while respecting individual rights.
Could you read the whole thing, Joe?
Well, we the people of Anchorage, in order to form a more responsive self-government, or government, whichever you, and to achieve common goals while respecting individual rights, hereby establish this charter.
And to achieve common goals.
second.
That sounds pretty good. It almost gets there, Joe, to what I'm getting at.
Almost. I'm not sure
Almost.
you
It's
did.
not quite.
Did you move? And was there a second?
Yes,
Lisa
second.
seconded.
Doesn't matter.
Could you do it again? To
Is
achieve
there any further
To achieve
discussion?
common goals while respecting individual rights.
well, why don't we say, and to respect, I mean, to keep the iambic pentameter going.
Why,
We do in order.
The point here, Fred, I think, is that there's something that we feel, this went to the whole matter of the term effective that we struck, that they're going to be swept up in a kind of mass movement of sorts through unification that just will make it more difficult for them to have their lifestyle. Or
Joe, may I suggest one change to that?
preamble wasn't going to solve that.
While accepting individual differences and rights.
No.
While respecting individual differences and rights. I didn't,
We're not writing the Bill of Independence.
rights or not?
That's the Bill of Rights.
Yeah, the Bill of Rights. We're not writing that. I mean,
Well,
we're writing a
You're
simple...
doing when you're inspecting, when you're respecting individual rights. Sherry was first.
I'd like to address what I hear as a concern that Fred seems to be voicing, and that is that why do we have to have this protracted preamble? We've heard comment at various public hearings, and I think it's well taken, that the people would like to see the preamble set the tone for the charter. And I think it's kind of important that people have been coming to us and saying, look, this is a community made up of a lot of individual needs and desires. And please make sure that your charter recognizes it. Well, I think we can go a long way toward assuaging fears of these people by having a good statement in the beginning that says, we hear you.
Where did you gather this opinion? At what public hearing?
There
must not have
were a
been
couple of
listened
people.
I listened to the public hearings, but they weren't representative to me of the community. The people that appeared at those public hearings represented special groups.
Yeah, always
Now,
happens.
let's talk about the community, the people that are...
One more. Lisa had a question.
Maybe it's, that people don't want to be thrown into a big group, into a cluster. They don't want to be a part of a group, part of an organization. They want to be recognized as a person. It's like in your government. Who controls
This is
what
right,
goes
Lisa.
on?
And most people don't like to be insulted either.
Why are we
See,
insulting them?
when you come along with a lot of candy wrapping and a lot of candy words, the guy says, I'm not stupid. I know what government is. I want government that's responsive, and I want government that'll set the goals out that we have, period. This says it beautifully. Why do you have to go into the Bill
No,
of
it
Rights?
doesn't. It says I'm going to have to conform, and I don't want it.
You're going to conform regardless. I think we're insulting the intelligence of the moving
the
forward.
floor next, Fred.
let me see if this still offends you, Fred, because I think there was some reaction to just the style of what I did. See if my second thinks this is an improvement. If the preamble said, we the people of Anchorage, in order to form a more responsive government, to achieve common goals, and to further individual rights, hereby establish this charter, would that make the thing more real?
And to further
Further or advance, support?
Further individual rights.
I like that.
That's getting a little more out of that motherhood business. Yeah, that gets a little more to the practical.
for the purpose of discussion, I'd accept that, but and to further, I don't like as well as to respecting them. I'm not sure we're doing much to promote individual rights. We're respecting what exists, but I'm not sure we're creating any new
Well, if you don't want
ones.
to second it, I'll second it.
You
I like
are. I'll argue that.
Let's start with the new one. And would you read it another time?
I think you've lost me. How many motions back are we?
Well, we're just with permission of second changing the last motion.
Joe, how about dividing that question to achieve common goals? I think we all agree that far.
Right.
Would you?
Common goals. We all agree
Let's
on
go
that.
as far as to achieve common goals.
You mean a more responsive government?
So it reads,
Yeah.
we the
Or do you-
people,
To achieve, comma, no, just more responsive
Okay, in order to
government,
form-
comma, to achieve common goals.
Right,
To achieve common goals.
yeah.
Now, from there on, let's try that last one again.
Why don't you stop there? Just put a period
Okay,
there.
what I'm trying to say is, and to, what I guess I would be inserting then would be, and to further or advance or support whatever the Charter Commission wanted, individual rights. And I think the argument can be made that that's what the Charter would do. You know, I can, we can already point to some of those things.
Say those words again. One of those I like better than the original.
All right, further, advance, or support, whichever.
To
we
support individual rights. That will buy it, I think.
that's unequivocal, maybe.
I think to support individual rights, I think that says it.
Okay, yeah.
Any
Let's
second?
try that on for a while and think about it.
Can we look at this?
Now,
Okay, after the word goals, you would.
Point of order, did you mean to drop self out of government in the second version?
I,
Oh, I hope not.
well,
Yes, we
Yes,
never did
yes.
get self in.
They dropped it out.
He had it in the first
You can
version.
add it.
No, he suggested. We just admitted we didn't put it in.
that's another subject.
Adding Mr. Josephson,
Then the addition, what I'm suggesting is to add the phrase, and to support individual rights.
Right.
now may I read it as I think I have
Sounds
it down?
communistic to me.
Is self in or self
Individual
out?
rights are communistic to you?
Yeah.
Andy, why don't you read it?
He fits into the polls.
Mr. Josephson, motion to amend reads as follows: "We the people of the Anchorage area, in
No.
order to form, we the people of Anchorage, in order to form a more responsive government and to achieve common goals, and to support individual rights." Excuse me. So that the difference is a more responsive government to achieve common goals
And to support.
and to support.
We the people of Anchorage, in order to form a more responsive government, to achieve common goals, and to support individual rights, hereby establish this charter.
is that,
Let's say it in English instead of hereby established. Let's say accept this charter.
No, that's not what we're doing.
No, we're
establishing a charter?
All right.
I have to love English.
Right,
Yeah, establishing and ordaining or one or the other.
Sherry,
I like the ecclesiastical flavor of ordaining, yes.
I would accept this as where we stand now, as the motion on the floor.
been moved and seconded. Is there further discussion? Mr. Parsons?
Well, someone, I think Dick suggested the word self, and I think it's a good word to be in front of government,
Why?
because I said so.
Oh, I'm sorry.
On that basis, I have no objection.
I object on that basis. Self-government, redundant. Not
Is
always.
there discussion by the second?
Unfortunately.
I don't have any strong feelings one way or the other, but I kind of like it without it.
Government is a collection of individuals who are all
think it's
voicing their rights.
superfluous.
That's what
I
constitutes
don't feel that
government.
strongly about it, I just like the phrasing when I heard it.
It's a collective group of people that form a government.
Well,
It is a self-government. I don't have strong feelings.
Mr. Chairman,
Dick?
Fred's right, academically, it is a group of people formed together for common needs, but, that's not what it is today. That's not what people view it as. And I think we've got to explain what it is a little more.
Are you speaking in favor of having self-government in there? then?
Really.
I don't mind having it,
I
and I don't
agree
mind.
with you.
Let's put it in and leave it there for a few days and see how it shakes.
We are going to have other cracks at this before
Yeah.
it goes out into the community.
Let's
And
leave it in and see if it gels with us.
Does the
How's it read now?
man who made the motion and the second agree to put self in?
Sure.
It's educational, if nothing else. It tells people what their duties are.
Would you like me to read this one more time? for
Yes,
the-
please do, Jerry.
We, the people of Anchorage, in order to form a more responsive self-government, to achieve common goals, and to support individual rights, hereby establish this charter.
Not and to achieve common goals?
No, I had it as comma, as, a list of things we're going to do.
This is in place
Is
of the
there-
original main motion.
This is where we stand now, is the
That's where
motion
we've
on the
gotten
floor.
to.
Right.
Is there any further discussion?
Can you read it once more? Can I,
Sure.
Chairman, can it be read once more?
We, the people of Anchorage, in order to form a more responsive self-government, to achieve common goals, and to support individual rights, hereby establish this charter.
Do hereby or?
No, just hereby.
If there is
We
no
hereby
further
establish.
discussion, the chair will entertain a question.
Well, Mr. Chairman, can anyone think of a better word for promote?
We haven't said promote in there anywhere. We
Or no,
said
support, excuse me,
Uplift?
Why don't we do this? At this point, we have a motion on the floor, and substantial agreement, I think, on that, on the substance of that motion. If we go ahead and pass it, we do have, when we get this first skeleton draft, we do have a chance to look at it again. That is important for us.
I think it is hard for people to hear it and see it, and so maybe if
very
if we have a little while to look at it. I
Get it
call
off
for
the
the
table, let's
question.
go, let's go.
All those in favor?
Aye.
Those opposed? So ordered.
Okay,
Now, Sherry, you've got...
here we are, we're
Name.
moving on. For those of you who do not have the copy of Article 1, Name and Boundaries, you can refer to your 71 charter and I'll tell you how it differs in our proposal. The heading would be Name and Boundaries, not Name, Boundaries, and Powers. Section 101, entitled Name, reads, "The municipal corporation shall be known as Anchorage, period." No quotation marks around Anchorage. That's not important. Just, the municipal corporation shall be known as Anchorage, and then strike the rest of it. The intent here was that somewhere back in the definition section,
In
if
the bonding
necessary, we would say, if the financial people say we have to do it, say that if where it is deemed necessary, the name city and borough of may be used. The idea being that it would only be in perhaps bonding situations where we would absolutely have to use the city and borough.
Or for any legal situation, I
Yeah,
don't
legal
Did you
situations, I
make a
guess.
motion?
wherever necessary.
Right.
I'll review this with you and then I'll move the whole thing.
As we go, then, I'd like to ask Dick, was there legal reason for including it in 71, or you thought there was?
No, I mean, just so you have the option to do it somewhere, that was important, but that could take place anywhere in the charter.
The opinions we've gotten so far, and we have a meeting on Friday with the bonding council, but the opinions we've gotten so far is that it's not going to be necessary to have it.
And let's move.
Okay. Boundaries and succession. Yeah.
And since this was done, I think, based on our consultation with some of the borough people, we're probably, I would say 80% sure that we can put a period after borough and omit the references to purchase and Vista.
So, in what you have in the 71 charter, there's reference to all other areas that lie within the city of Anchorage, but not within the borough and the date and so forth. Well, that has been ironed out, and there are none of those areas at this point, as far as we are told. Yes. We'll check that out thoroughly, but we've been told up to this point that
What happened?
Richardson
Annex
Vista
the
is
basin.
next
It's in the
to
borough.
the city. It's now in the city and the borough,
It's been next to the borough.
as well as to the city.
It's in the borough.
We were told. So, we'll check it out further, but it would be our recommendation that the boundaries section be just boundaries, not boundaries and succession, and that it read, "The municipal boundaries shall include all areas within the greater Anchorage area borough."
Would you still need on the date of ratification of this charter?
Yes.
I guess, yes, on the date of ratification of this charter.
Why not put that in the date of ratification of this charter in the transition period?
Well, because
In the transition section, because from there on out,
because Mary, the boundaries at that point will, I mean,
They're
I'm-
fixed forever.
Yeah.
The boundaries are not
All right.
transitional
all right,
in nature.
all right, I accept that.
okay, and that would be the entire section, or the entire article.
And the municipality one is out.
Yes.
Last would go into
Yes, the
transition.
powers thing. Now, we have, in the process of writing these various drafts, we've come to the conclusion that we're not going to be able to necessarily identify all of these things will fall in the final draft document. We may have to pass the parts and then take the parts and put them around.
Yeah.
So we may want to do a statement of the powers of the municipality, but not at this time, and not probably in this place.
We didn't address that last sentence, that Anchorage shall succeed to all rights, responsibilities, assets, and obligations of all previous existing municipal corporations
That's going to transition.
within
Lisa?
the other.
Why is Anchorage called a municipal corporation?
It is.
Well,
That sounds terrible.
No, it's a what do you got against corporations?
Municipality.
It is, it's a corporation, Lisa.
Well, but this, along that line, as a matter of style, I wonder if when the charter refers to the municipality, and if you have Article 1 saying municipal corporation shall be known as Anchorage, if you could just refer to Anchorage, I think it'd be a lot more appealing to people to say the executive power of Anchorage is vested in the mayor. That's what we're going to say, instead of saying the executive power of the municipality, or there's established in the legislative branch of
Kind of
Anchorage.
personalizes.
Yeah, it makes
I
it
agree.
identifies
Yeah, I
the.
agree.
I just mentioned that as a style.
I think so.
Good idea.
Good, John. Well,
basically, to answer Lisa's question.
Wait a minute. I like this idea too.
Mary, wait a minute. I'd like to ask Joe that, to address himself to Lisa's question there as to why is it called a municipality?
Municipal corporation.
Corporation,
I think that's a term of art in the Alaska statutes, isn't it? Rick?
I think that's the term commonly used in Title 29, but it's
It's a corporation in the sense that the individual citizens can't be sued. Would that help?
That's standard
An
language.
artificial
It's
person
used in every
standing
city.
to sue, and
Yeah, it's used in every city.
Joe, in your suggestion,
body politic.
in this boundaries, would we say Anchorage shall include all areas within the greater Anchorage area borough as out
I think
there?
all the way through, once you have established that, and you may need something in the way of intent to clarify, you know, if we're trying to get people to identify with this government, that it would be better to say the boundaries of Anchorage include the areas within the, you know, and Anchorage may exercise all powers not prohibited to home rule cities and get away from the municipality.
I think so too.
Lisa, makes sense.
Under name repair, I would like to move to amend to say the municipality shall be known as Anchorage and strike municipal corporation.
I'll second that.
I don't know that there's any great legal effect one way or the other, Joe. I can check it out a little more, but I don't see a reference to municipal corporation that just sleeps out at you.
Would you repeat the motion?
To delete, to strike municipal boundaries and insert municipality.
Municipal
No.
corporation.
Yeah,
It made, yes, I noticed that a home rule municipality is a municipal corporation by operation of law, according to 2908-010, so the amendment probably wouldn't change the legal.
Been moved and seconded to strike municipal from a corporation, correct?
No.
No,
Just strike municipal corporation and insert municipality.
Municipality,
Substitute.
substitute. And any further discussion? All those in favor?
Aye.
Opposed? Aye.
One again.
Mr. Chair, can we have a point here? It was brought to my attention tonight that maybe on these votes, particularly when someone is opposed, that we do a roll call in the minutes. Would you like that, or how
I
do
think
you
it
feel
would be
about it?
well done. Yes, I think.
For the record, it
Yeah,
might be
that's good.
desired.
It would be
yeah,
good.
Did we have an opposing vote on that one?
Yes,
One.
and I abstain.
Sherry, how do you vote?
It's
Yes.
hard to know with some of the
Yeah,
statements
well,
unless you make a point of.
Don't our rules provide that a system whereby a member of the commission may ask for a recorded vote?
Then it's a negative vote.
I haven't got the rules in front of us, but I think there is a provision.
Well, I would like as a matter of style to set it up one way or another unless.
Well,
it's
I think the minutes, we have a rule in the minutes, and we should, follow them. And I think if someone wants to be recorded, that there's a system to do that.
Sure. Would you like me to check the rules?
I need to get moved in that part.
That's one of the nice things you could put in your notebooks.
Well, at this point, I would like to have this vote recorded. I've asked for Sherry and Jim said yes. Joe?
Yes.
Lisa? Dick? Fred?
Negative.
Mary? Yes. I thought no.
Were you abstaining this time?
Opposed. I'm told I can't abstain,
Right.
according to rules. Is that right, Lisa?
That's right.
You have a conflict of interest.
Show me a man without a conflict of
Do we
interest,
have,
and I'll show
does the
you a
motion
fair.
carry, Mr. Chairman?
How's that?
Does the motion carry?
Motion carried, 5-2.
I thought that it required a majority
Majority
of
of the commission.
the
I
commission.
think you're right.
The motion failed, 5-2.
I know that.
That's why we had that 6-to-1 vote.
We have 8 people here. How did it? Yeah, what happened?
Passes 6-2.
It passed 6-2. We have 8 people here.
5, 6, 6 to 12.
I have them listed right here.
Okay. Gee, it's nice to know we can all add.
Nice to major and minor.
Joe, were you going to then propose an amendment to section 102?
Yeah.
In line with your,
No, I just think because this comes up all the time, that as a matter of style,
so we should say the boundaries of Anchorage rather than the municipal boundaries?
yes, I
Well,
think,
why don't we make that as a motion now?
well, all right. Okay, I so move that the reference should be the boundaries of Anchorage rather than the municipal boundaries.
Second.
Second.
Moved and seconded. Is there any further discussion?
Well, yeah, Mr. Chairman, what are we discussing? Just Mr. Joseph's amendment? To what?
It was an ongoing stylistic thing to say Anchorage rather than municipality of Anchorage.
To the,
Municipal boundaries of Anchorage.
Oh, no, strike municipal.
The boundaries of
Boundaries
Anchorage
Anchorage shall
include
That's right.
include what?
all areas within the greater Anchorage area borough on the date of ratification of this charter.
That's what I wanted to know. That's what you're saying, that's what you're asking, Fred. Okay. Mr. Chairman,
Mr. Fisher?
could I ask then,
Sounds like a minstrel show.
be definite about what's going to happen to the last sentence? Because I'm concerned about, I suppose, it's got to be taken care of, I assume.
Legally. Go to transition.
And it is going to go into the transition. Okay. Then, as long as we're discussing it because I think that we're also, by this motion, eliminating that 103 powers. What are we going to do with that?
We haven't come up with that yet. It was suggested that that not be in the front of the charter, separate from any limitations we might put on the powers. And I'm not clear in my mind whether we need a statement that we shall exercise all powers, or if we do, where we should
Should be
put it.
further down in the charter.
You can put it in the last section among general provisions, or...
Okay. Yeah, well, that's fine. Mr. Chairman, as long as it's understood, I think we need it in the charter.
I agree with you.
In advance as to location.
And I don't care where it is. And I think it's preferable to be elsewhere, frankly. But as long as we have the understanding it's going to be in the charter,
Clipped and hung to be
Then-
put somewhere.
then that's fine.
Yeah.
All right.
Question has been called for. All those in favor?
All right.
Aye.
Those opposed? Ready?
Okay, that I would propose.
No, I'm with that one. I'm with that one. I'll buy that one.
Okay, we move on now to elections. Rick, you have
The name
a copy?
corporation gets
Goody.
weights to go with it.
I had this moment of panic that we weren't sure.
Well, it was close. It was really close.
Then the
No, that's
community,
why he limited.
then the
I have a
community.
suggestion today in relation to this business of money.
Man and his judo
Why do you hate a profit? There's nothing wrong with a profit.
This is a bad day.
We should, you hate profit.
That when we speak about the,
You hate profit. Are you against profit?
Ladies and gentlemen, Mary has a comment to make regarding...
I was given a suggestion today that when we came to enlisting the powers of the government, such as the assembly and so forth, that right above that we somehow get across the idea that the power, real power, is retained in the people through the right of petition. And subject to that, the assembly has the power granted to it
Excuse me
by the
just
vote.
1 second.
Mary,
I'm not wording it right, but that's the idea.
I don't think, and Joe can correct me if I'm wrong, but as I understand it, state law provides that it does not lie with the people, it lies with the government at this juncture. Is that right, Joe?
Oh, boy. Where's Rick Burnett? There he is.
I believe that there are strictures on the petition power. You can't petition. I'm talking that it was suggested to me today that if we could get across in this charter that the real power is retained by the people through the right to petition, with minor reservations, and I think there is a reservation in the Constitution.
Mr. Chairman, the statutes talk about the legislative, the entity as exercising powers, such as legislative powers. The power of the people is not through petitions, through their sovereign capacity that they elect the people who run the government.
But if they retain the ultimate power and are granting only part of them by their election process, is what was proposed to me.
I would think that statement would complicate it.
Any comments?
Really?
Not really, Mary, I'm having trouble. As far as this provision is concerned, of course, a statement of this sort, tracking the constitutional language, is necessary to accept the grant of power for the municipality. Now, you're talking about something other than the legislative power that the municipality is going to exercise. And I'm not sure what it is.
Well, it's the ultimate right of the people to petition and change any law that the legislative body makes, except where they don't have the power for it. And I think it has something to do with, you can't say you can't levy any taxes or something of that sort.
All right, now, with respect to initiative and referendum, we do have to provide for that in the charter.
Yeah.
And initiative and referendum can cover everything except certain specified things like appropriations and local and special legislation, a few other mill levies.
Well, this suggestion was to the effect that if we stylize it in such a way that that power of referendum or power of petition showed itself up as ultimately being more powerful than the granting that we give to the legislative body, so long as they wish to exercise it.
I can see putting something of that sort maybe into a general provision, but I would not think it a good idea to mix that idea in with this specific grant of powers, because I'm real superstitious about deviating from the constitutional language in that respect. I could see, you seem to be talking about something like in the Declaration of Independence where they say, for this purpose, government should institute and run men, and should governments become destructive to these ends, it is the power of the people to change them and overthrow them, and so forth. That sort of,
Yeah, that sort of thing.
yeah.
And that it should come before we talk about the grant of powers that we are granting to the legislative body.
Fred?
Well, isn't that going to be covered under the initiative and referendum section?
I'm talking about style. I'm talking about style. Somewhere we're going to speak to it.
Could I
Yeah.
suggest that we hold off on this and perhaps do something to it in subcommittee first and bring a recommendation back?
Okay.
Because we have sort of a heavy agenda for tonight.
Yeah, let's try
But I think it needs a little more working on.
You see what I'm trying to...
Yeah, as long as you're talking about reassurance of a sort,
Yes.
rather than a legally operative.
people that mean groups.
Well, it is a operative through the
Why do you think we're...
power of referendum.
Right, that's all.
That's their really like or not.
But you're just talking about a way of highlighting that power.
Yes,
legally exists.
highlight it before the...
Oh, thank you. How soon can I get on your couch?
I'll get a small group by then, I'm sure. Okay.
Let's get on with it. Let's go to
All right.
Article 5.
Mr.
Jerry?
Chairman, you have fellow commissioners, you have in front of you the section on elections, which has been quite condensed from the 1971 version. If you would take a moment to read it right now before we begin, and then I would ask Rich to comment on some of the things that we've done, things that we've omitted and so forth. Would you like me to comment? Well, I can tell you, in Section 501, we have said that the general election shall be held annually on the first Tuesday in October unless otherwise specified by ordinance. That allows the municipality some flexibility in case there is some great overriding reason why the first Tuesday in October would be a terrible time to have an election. The election procedures is a condensation of several other sections, providing that elections will be nonpartisan and that the Assembly will establish the procedures for the elections rather than spelling out at this point what those procedures will be. But we did want to guarantee the provision would be made for absentee voting. And we have preserved the fact that in cases of tie, the Assembly will determine the successful candidate by lot.
What's your provision for the first election?
That would be the transition provisions. In the notes here at the bottom, I think we speak to that.
Last sentence from the second page. No, that goes to the apportionment plan.
Oh,
I'm not talking about that. I'm talking about the procedure for ballots and all the mechanics of the election.
present mechanics will remain in effect until changed.
That does have to be a transitional provision, I think, because if you put it in the body of the charter, the provision for the first election goes with the document for
So you do
years.
plan to address that in the transition now?
Yeah, I would plan, it would be covered in that part of the transition which specifies that current ordinances of all sorts persist under the new government until
Yeah, that's where it belongs.
specifically changed.
Continue, Sherry.
Rick, I'm going to ask you to speak about the qualifications of voters in the assembly districts and apportionment because I'm not that well versed.
Sure, it's not, I believe Lisa had a question about the 30 days. The requirements for municipal voters are spelled out in the statute, which is applicable to us. It does require 30 days residence. That, in other words, we can't shorten it or lengthen it at this point. I'm not sure that there's anything else mysterious about that provision, the qualification of voters. On the apportionment question, this is a matter of policy for the full commission to consider, but there's been a lot of discussion in the subcommittee, particularly about how to handle the first election and still provide, how to handle the first election with a minimum of pain, who's going to be upsetting the voters and so forth, and yet leave the whole document flexible enough so that altogether different types of apportionment, single-member districts or whatever, could be enacted by the assembly later on. This reference to districting, apportioning, and reapportioning in the manner provided by law is fairly close to the apportionment provision now in Title 29, which does apply to us. Title 29 just says you can apportion any way consistent with the Constitution. And I'm leaving us so this language leaves us about that same degree of latitude in the long run.
We had a rather lengthy discussion concerning maps and things like that in our subcommittee. And what we came up with is if the commission decides that what we will recommend is multi-member districts, that perhaps the best thing to do would be to go with the present 4 districts which have just been established and canceled out in court, and that changes such as putting Scenic Park back in the district where it more rightfully belongs and so forth could be made at a later date by the Assembly and put on a ballot as a separate issue rather than confusing the charter with changes in districting and apportionment. All of that has to hinge, of course, on what we decide we'll do about the people.
Mr. Chairman?
Joseph?
I have some trouble with this. Do you mean that after polling and having hearings and deliberating and having an opportunity as charter commissioners to speak to the question of what the districting system should be, that we would elect just to be silent about it?
I think in the section on the Assembly, we will say how it shall be composed and so forth, I think.
Well, let me,
That is what she said.
Lisa has a question.
Yep. This is kind of along the same lines as Mr. Josephson, but if we said in the Assembly that we wanted single-member districts and then in transition that we would have the new Assembly elect with the current reapportionment plans, wouldn't we be violating the charter?
Well,
So,
if for the sake of convenience, because we didn't want to become an apportionment board, and we didn't want to get into that issue, we decided to have single-member districts, but allow the first assembly to sit on the present multi-member basis, that would be, one permissible option that we could take. But what concerns me, now, where would it be? Let's assume that the chart, and I'm not speaking because I have a bias in this respect particularly, but suppose that the majority of the Charter Commission wanted single-member districts. Where would we speak to that? You're saying that as long as they satisfy state law and the Constitution, the Assembly can do it any way they wish, regardless of our wishes.
Now, excuse me.
Is that right?
Go
that's
ahead,
right.
Rick, and
Okay, this did come up, Joe, and I say the point, I believe, in the subcommittee was, as you point out, to avoid becoming a reapportionment board for the first time around, and yet still leave it flexible enough so that it could become single-member district later. Now, as to your concern about making sure it becomes single-member district later, for instance, we had considered the possibility of a provision that in 5 years or something of that sort, in a certain period, within a certain period of time after establishment of the new thing, the Assembly shall redistrict to a single-member district basis, on a single-member district basis, or something of that sort as a possibility.
But you rejected it.
I didn't
no,
reject it.
I don't think the subcommittee made a determination at all about whether to recommend to use single-member districts or multi-member districts at this point. That, in the 71 charter, was addressed in Article 2 on the Assembly, and not in the section on elections.
Okay.
The only way that it was addressed in the election thing was in the first subsection of election districts. It said that there shall be one at-large district comprising the entire municipality and 11 individual districts. Well, if we don't put that under the elections article, we can put that under the transition article. For the purposes of the first election, there shall be.
Just a moment. I think that as I read the text of Article 5, coming down to Section 5.04, and listening to your comments, I have no problem with that. But then I look at the note, which says that old Section 5.08 dealing with election districts is entirely rewritten to leave the Assembly free to provide for any system of apportionment. I do have a problem with that. I do too.
Me too.
Because assemblies and legislatures are notoriously unwilling to reapportion themselves in a responsive way. Lisa?
If we, just left it that way and did leave the Assembly free and said, in 5 years or whatever, you have to put yourself in single-member districts, then when it comes down to putting themselves in single-member districts, they're going to really have a hard time. They want to put themselves in the best area, probably, where they might be elected from.
I have to agree that at this time, setting up districting 5 years from now wouldn't be a too sharp thing in my estimation. Jim was next, and Dick.
Well, I'm troubled. This is a nice way of avoiding a controversial issue and letting it be taken care of other ways, but I think it raises as much controversy as it avoids in terms of the testimony that you've heard. I am developing a bias at this point in terms of what I think is preferable for the setup thing, which may be just as controversial. But to leave it out, I think, may put us in a vulnerable position in terms of the total document.
Well, I would.
Dick was adding something.
Well, I don't understand Jim's comment.
My comment is that, say, for example, I favor mostly multi-member and maybe some at large kind of thing. And there are other people who are saying, we want single-member districts. It is a point of issue, maybe because we put it on that throwout sheet. It is something that is
issues for years.
and continues to be, and to not address it in the charter may be a convenient way out to get the thing over, but put us in a terribly vulnerable position in terms of the conversation that Joe had made here, that is that once the Assembly has the opportunity to again put themselves in a king of the mountain position, they will do so. And I would like to avoid that.
Well, I didn't understand that that's what we were doing by acting on this section. I mean, that will be addressed elsewhere in the charter.
But how
I
about
didn't hear that or read that here.
504 though? Read 504.
Well, I did.
Again, I could support Article 5 with the understanding that the Assembly article will contain a reapportionment
That's right.
plan in which we express our
That's what I
intent as
understand.
far as districting. I'm only quarreling with the note here, which indicates that we will just abdicate this function and let the assembly work it out. That's what I
Okay, that's fine. It's a policy decision for the commission to make what they want to provide for down the road. I'm not sure what to consider your options. You either put a map in with the charter, which I think the consensus says would be a problem, or you provide for a reapportionment board of some sort in the charter, something other than the assembly to do the job.
We're not going to do
All
the
right.
reapportioning though.
All
are we?
right, let me make a comment here in relation to this map business. I think that this area realizes that in the next 5 years, we're going to have a great increase in population. And if we provide in the charter, if we go to a district, reminding them that whenever the population increases by so much, it is automatically to be reapportioned, then I think we would take care of the situation. Because that would let them know that if they didn't like the way the district was apportioned, it was going to be changed within, say, 5 years.
Mr. Chairman, I would like to try and explain
For 6
better
years.
what I think the subcommittee had in mind here, and I will apologize for not doing it better in the beginning. What I had thought we meant by districted, apportioned, and reapportioned was that in the assembly article we would say something like there shall be 11 single-member districts or there shall be 4 multi-member districts. And that by saying districted and apportioned, I meant merely moving the lines around to more adequately reflect changes in population in the area, not changing the basic premise that we will set forth in the assembly section on how many districts and how many members. Now, maybe I didn't read the subcommittee right. Is that just a second?
Well,
May I ask-
I fully agree with what Jim and Joe are saying, but can we say it, in other words, can we spell out in the charter the method of representation, either single member or multi-member, and not go to a districting? I mean, can we spell out the mandatory, and then leave it up to the assembly to
draw the line?
draw the line?
I'm not sure I understood what Mr. Garnett was saying. What I think I heard I didn't agree with. And this relates to what Ms. Parker said, if we want to avoid the matter of mapping, we can say that the election of October 1975 will be on the basis of existing districts, but that the next election will be, if this were our desire, would be held on an at-large basis or on a multi-member basis or some combination. And we would not have to set out the methodology for that. The assembly
what I'm
could
saying.
decide that, and if someone was dissatisfied, they could go to court.
Why can we do that?
I think that's one of the options that I was trying to get across in the beginning there, that the charter could provide that the first election would be held under the current plan, but as of a certain time in the future, it would be another specific way.
And that would be in transition then.
Yeah.
I think that's good.
Any further discussion on it?
Well, that makes sense.
In which case,
Is this the substance of the entire?
This is it.
All right, let's have a little further discussion on this. That might work. But when would be the logical time in the future to do this? Everybody has to be elected now. Never in the future will everybody have to be elected.
Mr. Fisher?
So you've entered in a very improbable. You're causing somebody to have a short term or a long term.
Dick?
All right, so what we've decided then is we've not addressed ourselves at all to the original portion in this section, right?
No.
Right. All right. So that's all clear now. That's all taken care of. All right. The next thing is, what does Title 29 say about reapportionment, if anything?
Has a pretty comprehensive scheme about reapportionment, which applies to us as of now. It says the Assembly can apportion itself any way it wants to, consistent with the U.S. Constitution. It must do so within 6 months of each census, and it must do so upon determination by the Assembly that it's currently malapportioned, and it must make a determination on that point if it gets a petition of X number of people. If it doesn't do it within the time frames allowed, then the local affairs agency does it.
Okay, fine.
He's covered. That does apply, so
Sure as a no.
That applies to all rules.
to what extent we change it?
In which case, to move things along then, if we're all agreed on that, I'd move that we accept the articles on election as written.
Oh, no, we'll do it. With a comment about
Is there a
There is
second?
no motion on
Is
the
there
floor.
a second?
No, there isn't a motion.
I made a motion.
Right. Well, Mr.
I'll second the motion.
Chairman, I'd like to divide that question at very best into 501, 502, and 503, and 504.
Ask the question to be separated then.
Move for
Parliamentarians.
separation. No, it's not separation of the question. It's a division of the question.
Well, how about acting on my motion? If it fails, then you can go ahead and split it.
Certainly. I'd like to discuss each one of these. I've got some points I'd like to make.
Next, is there a second?
For what?
Divided.
Move to the division of the
I
question.
don't know whether that's right.
That's right.
All right. If there's different procedure, what, tell me. All those in favor? Opposed?
I'm opposed.
Or Fred. By
One
himself.
against. That's correct.
I think it's just a waste of time. That's why I'm opposed to it. Now let's come back. All right, we're going to split them. Now let's take one.
Yeah, Mr. Chairman, may I address myself to this? Okay, I really don't like the unless otherwise specified by ordinance, and I think the Assembly is going to consistently delay the election if for no other reason that they'll remain as the Assembly, or whatever we call them. And I think there's going to be a habit to procrastinate, and I think the people of Anchorage have the right to have an election held on a specific date unless the court says separate. I feel very strongly about it.
Mr. Chairman,
We ought to put that in.
we had this added, we had quite a good work session with the two clerks, the borough and the city clerks, and Dick Weinig and Joel DeWar, who work on apportionment. And the city charter, I believe, does not say unless otherwise provided
says-
by ordinance.
It does, but it requires that a change in the election date not be effective until 1 year
Until 1
after,
year after.
which is not a bad idea to prevent the problem or to slow down the problem Dick's talking about, of current assemblymen prolonging the current election or postponing. You remember that, Dick, in the city charter?
No.
Would that speak to your problem?
What did it say?
The city charter has a provision almost exactly like this, except as in our compensation provision, it says, a change in the date of the municipal election shall not be effective for at least 1 year after, or something.
I would read that section if you
Oh,
want.
that's different.
A regular city election shall be held annually on the first Tuesday in October or such other date as the council may provide in the code. The date of holding regular city elections may not be changed by the council at any time less than 1 year prior to the date of the first regular city election
But
effective.
that's substantially different than this language.
Yes, I know it is. This language was proposed by the two clerks as a means of giving some flexibility
Mr.
to
Chairman?
meet special circumstances.
There's no question in my mind at all that it'd make the job a lot easier for the clerks. Frankly, that doesn't concern me. I'm concerned with the rights of the people of Anchorage, and the rights of the people of Anchorage to have an election on a specific date.
Well, when you're elected, are you elected for a term that expires on a day
It
certain? Or
expires
is it-
when the next person's elected.
That's right.
Seat is seated.
Until your successor's qualified.
You know,
I understand Dick's his hesitation, and I think maybe we could define what sort of circumstances would be acceptable,
Well,
perhaps.
Joe?
are we
Well, if you look at 29-28-020, which says the date of a regular municipal election is the first Tuesday of October annually, or on a date of election, or at an interval of years provided by ordinance, my question is, would that allow the latitude, even in a home rule community, to have the date changed? Doesn't it contemplate a date of election and a fixed interval? 29-28-020.
Well, yeah, I mean, this gives general law municipalities the power to change their election date by ordinance, as is the case with the borough. So we had the question of whether the elections could be set back to accommodate the charter schedule. The borough has no problem. Under this provision, it can move its election date anytime it wants to. Now, the city is restricted by the provision of its charter, because of that one new business.
So we are locked into having a city municipal election in October, and if we try to delay the municipal elections, we're going to have...
My question was whether the legislature had allowed municipalities of any class, home rule or otherwise, to do what Mr. Fisher fears would be done under this provision.
The answer is yes.
Including home rules.
Well, yeah, a fortiori, except where you have a case like Anchorage, which in its charter has restricted itself beyond what general law has done.
Oh, I see what you mean. But, all right, okay, I guess.
I'll try again, Joe.
Well, I was saying that they have in mind a date and a fixed interval between elections, but perhaps since an ordinance can be amended, they don't.
Dick, are you so concerned about this because of the recent haggling and hassling between the two governments and the changes of dates?
Yeah, partially. I'm concerned about this because of a particular government philosophy that I have, which is to not impinge upon the rights of individuals or the people in the area in any way. And, you elect an assembly. You give that assembly the right to delay the time in which they're re-elected, or a portion of them is re-elected. I think if you do that, they'll take the opportunity to do that.
Now, I seem to recall the two clerks saying something about some state election being changed to almost coincide with this first Tuesday in October, some other election that was being proposed to be changed.
The feds are thinking of moving their election date.
Yeah, I guess that's what it was.
No, there's been a proposal in Juneau to change municipal elections to spring rather than October.
Whatever it is, there's some proposal that they were talking about that is that's on the books that would make it mandatory to have a charter amendment in order to conform to what's happening elsewhere.
But you would need this language. You could say then, in that case, unless otherwise required by Alaska law.
It would override if it's otherwise required by Alaska law anyway.
Sure it would. I mean, if someone passes if the state of Alaska passes that law, that statute, it will apply automatically to home rule boroughs. And home rule boroughs
Not necessarily automatically, but if they say it does, then it does.
well, it'd have to, otherwise it'd be a mess.
What's that?
Tell me, what would make it mess if Palmer elected their officials on different days than I have to elect mine? What would make it a mess, Dick?
Well, if half the municipalities in the state were one way and half were the other way?
What would make it a mess?
Well, I don't know.
That's maximum autonomy. Local autonomy.
What would make it messy to do
Well,
that?
Joe?
I have another point on this section. Is there an amendment pending?
No, I'll move to strike unless otherwise specified by ordinance.
Inasmuch, we didn't explain that in the portion, I can't
So
go.
motion to amend.
We were forced into it.
I'll second the amendment.
Please repeat the motion.
Motion is to amend the main motion, which Mr. Scheid has made, to strike unless otherwise specified by ordinance. For the period at the end of October.
Otherwise, seconded by Joe.
Thank you.
Is there further discussion?
Question.
Well, question at this time.
generally speaking, unless there's reason for lengthier language, I vote for the shorter version always. And I'm just trying to be cautious to see if there's any reason for that added, unless otherwise.
All right,
They
let
can
me
always
speak to
specify
it.
by ordinance later anyway, couldn't they, even if the charter,
No.
by charter amendment then?
Charter amendment or state law requirement that applies to home rule.
I'd like to speak in favor of leaving it in. Now, let me explain what happened. We thought we had an apportionment, and the city challenged it in court. Who's to say a citizen won't challenge it in court? And because of the challenge in court, it caused the postponing of the borough's election last year.
Yes, but
And we, at that time, had to beg the court to tell us to postpone the election till a certain date. Because the way we were set up at that time, we couldn't just by emergency ordinance change it.
Joe?
It would have taken a regular.
I was about to say that I think the court did that, and the court does that. The court has, in other cases, changed election dates and changed the terms of senators, contrary, if you want to put it that way, to the state constitution. I don't mean to argue the case. I'm saying that provisions like this are overridden in particular circumstances by judges.
Well,
That's why
perhaps that's all that's necessary to be able to have a judge overrule it if something beyond the control of the municipality causes a postponement.
Well, and that would be fine coverage as far as that point of issue is concerned. And I'm not sure that, I think it's a major change enough so that if they wanted to amend it, they would be amending the charter, so to leave it as it is.
But a charter amendment, I think we might specify that a charter amendment could only occur after a certain procedure, and there might be a case where we're giving a lot of trust to our legislative body, and it bothers me not to give them the flexibility here where we're giving them flexibility elsewhere.
Mr. Chairman?
Fisher?
I'd like to speak to that. You know, Sharon, I'm willing to give a lot of flexibility and a lot of power to the legislative body. I think I'll usually speak in favor of that. But one thing I'm not willing to give them is the right to extend their own terms. I'm just not very happy with that.
Now, you see, I don't see that changing the election would be used as a tool to extend terms.
I know, I do.
It could be.
that's the difference. Well, if you have
I believe I called for the question.
Well, but that's not binding so long as there's further discussion.
You know,
Mr.
motives
I'd like to
are-
ask you.
Yes, I was just going to say, I've sat in assemblies and so forth, and I think that motives become very mixed. It's never really that blatant a thing, but if I could see the situation where the argument would be made that, gee, last October we had a terrible turnout because of the weather, and let's experiment with having it in spring or something of this sort, and where a member would vote for that proposition, not because of a blatant desire to perpetuate himself in office, but ostensibly because of the argument. But certainly, would you agree, Mary, that
I'm
your
not
motives become...
I'm not objecting to take it out, Joe. After I've thought about it, if you tell me we have that recourse to court to request that always, I'm not objecting to take it out, because certainly we can go to the court over any reasonable and ask them to tell us to.
Sure. Is there further discussion? Question. Questions called. All those in favor? Aye. Those opposed?
Aye.
Terry Holmes, Jim Parsons. Any other opposed?
Yeah, I don't know what I'm doing.
I have one question on this section, Tom. I know I'm going to get shot down.
On which question?
This is 5.01. Did you give any consideration to whether it should be the first Tuesday in October, or whether they're getting married and having it coincide with other elections, such as the November?
I'm kind of sorry that we're doing this now without our clerks here. I got a little bit embarrassed because we invited them to come to the Friday noon meeting and we didn't have a quorum. And so I didn't ask them to come again tonight. I perhaps should have, but I think they would speak as a matter of procedure that it would be terribly confusing. I would find it as a voter terribly confusing to wind up with a federal, state, and local slate all at one time.
Very convenient, though.
I would
Convenient, but for some people, confusing to the voter, confusing
But can you do
to...
that under the stat, under 29? Can you change
Oh, yeah, you can do it.
Joe,
to any month?
I have heard Mary Nettleton and Mary Coffey both speak to the confusion to the voter of too many issues on the ballot. I have strong interference on relation to
You
that.
did get shot down, Joe.
Well,
Let's go to 502.
All right.
let the minutes reflect that.
Let's go to 502.
Mr. Chairman, don't we have to vote on 501 as a matter of procedure?
We did.
No, we'll vote on the amendment.
Yeah.
All right, you want to go back and vote on the...
Question?
Yeah,
Go back.
call for the
Let's
question
let it carry.
on 501 as amended.
501 as amended. All those in favor?
Aye.
Those opposed? So ordered. Thank God.
No, Dick.
We have a
Sherry, proceed on
Well, I've already spoken about it. I
further discussion.
Yeah, Mr. Chairman. What's there doesn't bother me a bit. It's what isn't there that's bothering me a little bit. I'm wondering what Title 29 says about notices of election, and does it address itself to notice?
There's all kinds of stuff about it, I think, Dick, doesn't apply to us. And,
All right. So under this, then, the Assembly could provide that there really wasn't any
wait a
notice.
minute, let me just get back, I have to back up.
You must think the Assembly is a bunch of crooks.
Yeah, well, that's right, now that is applicable to us. You can't call a special election except for 1 day's notice.
Well, unless there's 20
But the main provision in Title 29 is that the Borough Assembly shall prescribe the general rules.
Well, no, could I finish? All right, now, let me understand this, because it's important, because I think that there should be notice of elections, both general and special. Well, no, wait a minute. General, as long as we've got a firm date now, is not bad, but special elections should require notice.
So-
Now, they do require notice for home rule municipalities in the Title 29.
The provision, quote, "The Assembly or Council may call a special election upon at least 20 days' notice," referring to special elections only, "is applicable to home rule municipalities. Other references to notice are not
All right.
applicable to home rule municipalities."
Just want to understand.
But the provision in Title 29 relating to municipal elections now provides that the rules for conducting municipal elections shall be prescribed by the Assembly. In other words, they are about as general as we are in that regard.
Lisa, did you have another question?
No.
All right, Mr. Chairman. Could I ask another question then regarding nominations, which has also been, what does Title 29 say about that, if anything?
It says, "The Assembly or Council shall provide by ordinance for nominations of elected officers, by providing for declaration of candidacy or petition requiring the signature of not more than 10 voters or both. Not specifically applicable to us. General power in the Assembly to do it with a few limitations."
I didn't follow that.
Okay, I'll do it again. It says nominations.
No, I followed the verbiage there, but I couldn't understand what you said about
Okay, what I was...
whether or not that's applicable.
Okay, it is not applicable specifically.
Okay.
My only point was that as to the general law here, the Assembly is given power to decide how nominations will be handled, except with the limitation that those procedures shall include provision for petition by 10 or more, by not more than 10 voters, and for declaration or vote.
And that's required by law and applicable to home rule
No, none of
municipalities?
that is applicable to home rule.
All right, so in this municipality, by leaving that out, the effect of it is that we can do anything, or the Assembly can do anything it wants to with regard to nominations.
Yes.
All right.
Now, Mr. Chairman, we had discussed all of this. In the city charter, it does not spell out notice, except notice in special elections. And what it does do is give a list of what the council shall provide for by ordinance, and it goes into nonpartisan nomination and printing of ballots and so forth. It was felt that, among other things, there are several new and different ways of handling nominations, which in the future the municipality might wish to consider. And that,
Such as?
well, one way is a deposit refund method. And I'm not advocating this, but you would, when you picked up your petition, you would put down a deposit. And then you would run for office. And if you garnered at least 10% of the voters voting in that election, your deposit would be refunded. If you did not get at least that many, or 5%, your deposit would be kept. This is one method whereby you eliminate people filing for office who are not serious candidates. There are several other
Put a premium on being rich, so it doesn't bother you losing. Put a premium on being rich, so it doesn't bother you to
Well,
lose.
now, Mary, I said I don't advocate
I
this,
understand
but there
that.
are many different ways of doing it, and I think the feeling was that we could be general and leave a lot of latitude to the Assembly as far as procedures go. The city has done that in their charter.
Sounds all right. I don't see anything wrong with that.
I suspect democracy allows a certain amount of nuisance candidates, and it's one of the, no one said democracy is the most efficient, and I'm willing to let it in with no deposit bottles.
What's the proposition before us? Someone moved on
502.
502, okay, and Mr. Chai's motion has been divided.
All right.
In which case, I guess we have to have...
Because it's been moved before.
Oh,
Ask for the question.
yeah, all right, he asked a question, is called for. All those in favor? Aye. Those opposed? All right, 503.
Mr. Chairman, may I make a point here? We are doing the tape as a matter of permanent record, and I just noticed a lull when everyone seems to be interested in a new concept. It got very quiet, but I'm sure we got a very good tape. But when people are aggravated or bored, the noise level on the pens going on and on is extremely high. There's a lot of paper shuffling. If you would remember that for posterity's sake, it would be nice to keep those noises down.
Okay, Lisa?
I have a question for Rick. If I moved from Fairbanks to Anchorage and there was an election the next day, then I could vote in that election?
According to this report? Yeah. If you were a qualified voter of the state of Alaska and you had all those subjective things that go to make up residency in the new municipality, I'm
I thought you said it was a
80%.
30-day.
Well, there is, but see, the 30-day requirement relates on, wait, let me just see.
No,
30 days.
no.
30-day requirement. I
Oh,
thought
okay, I'm sorry, I take it back. It is a 30-day
That's
requirement
right.
for residency in the municipality.
District.
In the district.
Municipality, not district, according to the statute.
So I could move from District 7 to District 9.
Still vote yes. I'm sorry, Lisa, it is. I was thinking it was a state requirement, it's municipal. Joe, 30
The state
days.
requirement would be for 30 days irrespective of the language of 503.
Yes, well, by saying a qualified voter, let me back up. The voter qualification provision in the statute as of now is applicable to home rule. And the voter qualification provision says that a person may vote only if he's a U.S. citizen qualified to vote in state elections and has been a resident of the municipality for 30 days immediately preceding the election.
All right, but now, this is one of those shifting sand
Right.
points.
That's right.
If a court strikes down the 30-day statutory provision, or the legislature changes it, then the charter would allow Ms.
Just-
Parker's hypothetical case to work.
That's correct.
Now, if,
Lisa?
I was going to make a motion to, in section B, after A, insert 30 days.
You wish?
After, on 503B, after A, put in 30-day residence.
How about after municipality for 30 days? As in the statute, is
For at least 30 days.
How about Anchorage for 30 days?
Yeah, okay.
Mr. Chairman,
Sherry?
do away with our 30-day provision
Yeah,
in
what
the
I
charter?
thought, Lisa, was what Joe was speaking to. Obviously, if the court says you cannot require 30 days residence, then you cannot require it. The problem I thought Joe was speaking to was that if the state law is changed so that 30 days is not necessary, we would be unprotected in the sense that our charter would not require 30 days.
Oh, unnecessary rather than unconstitutional.
That's right.
That's the distinction.
Yes. Do you still want me to go over that again and show you?
No, I think I'm with you.
Been moved and seconded to amend B under 503 to read a resident of Anchorage for 30 days of the election district in which he seeks to vote.
Mr.
and
Chairman,
that would allow him to be just 30 days in municipality, but 1 day in the election district.
Yeah. Yeah.
Well, that's right, on the wording proposed, right, worded that.
That's fine. I agree with that.
You can move
Just
anywhere
because
within
you
the
move
city.
around in the city, I don't think you should be deprived of your vote where you expect to be living.
We ought to add the language immediately preceding the election,
All
probably,
right.
because you don't want a guy who's been on 30 days 5 years ago.
Do you wish to add that to your language, Lisa, Mary?
How is your amendment now, so it reads?
A resident of Anchorage. Immediately preceding.
It would read, a resident of Anchorage for 30 days immediately preceding the election, and of the election district in which he seeks to vote.
Is there further,
Community resident.
Mr. Chairman?
Mr. Parsons?
I get the feeling, even after all this discussion, that is included in there by inference currently, and that there is no reason to insert it.
The point is, I don't know about inference. It's included in there now by reason of the statute, which requires 30 days. It's applicable to us. The concern, I think, Joe had and others, is that if the statute is changed to eliminate any residence requirement, by that I mean not a court decision saying that such requirements are invalid, but a statutory change. Our provision, as originally worded, would not provide for 30-day residence.
Well, that's sure an awkward sentence the way we've got it. It's an awkwardly worded sentence.
Resident of Anchorage.
For the previous 30 days and of the election district in which he seeks. For the previous 30 days.
Well, previous can be any time prior to. What you're trying to avoid
Yeah.
is this guy who was 30 days 2
Yeah.
years ago.
I think we can clean up the language if necessary, but the sense,
I accept the sense, because most folks don't know what the statutes say, and they will want to know whether they have to be there or not.
How about Mary, a resident after and?
Well, I think we are in agreement on what we're after and the editorial
You can work on it, Rick. Suits me fine.
language is to be.
is there any further discussion on the amendment? Not all those in favor?
Aye.
Those opposed? So ordered. Now we'll speak to the, I guess, to the section as a whole.
No,
We got one to go.
504,
Right.
please.
Right.
So I think what he means is that this is an amendment to 503B.
Oh.
Therefore, we must vote on 503 as a whole.
Okay.
Any further discussion?
Question.
All those in favor?
Aye.
Those opposed? So ordered. Now, section 504, Assembly Districts and Apportionment.
Mr. Chairman,
Rick?
if it is the intent of the commission to provide in the assembly section or elsewhere that after a certain time there shall be single-member districts or some other specific type of district, this wording probably should be changed, at least to the extent of eliminating the word districted. If we say that the assembly may be districted in a manner provided by law, that is allowing the latitude to change the form of districting.
Yeah, I think we better, I make a motion that we strike, that we omit districted. The assembly may be apportioned and reapportioned in a manner provided by law, striking the word districted.
Is there a second?
Second. Well, yeah, Mr. Chairman, can't we eliminate reapportioned also? Doesn't apportion really cover it?
No, not quite.
Doesn't
Wait
reapportion?
a minute.
Reapportion covers it then.
Rick? The distinction, Dick, as I see it is, and of course it's the procedures for carrying out reapportionment are spelled out in the law now, but that might change. And what we're doing, apportioning is the first time, and reapportioning is thereafter. And the procedures for doing it thereafter probably need to be spelled out somehow.
Well, that's true. Okay, but in that case, can't we eliminate apportion?
Well,
Because,
I suppose.
yeah,
Yeah.
we could, may be reapportioned.
Just
The
reapportion.
assembly may be reapportioned by in a manner provided by law.
Words left.
I think he's right.
Mr. Chairman, may I ask Rick
Sherry?
whether that means that the lines on a map can be changed to reflect population changes? Is that what we're saying?
Yeah, well, now, this is a problem. Maybe we need, let me explain these concepts as I see it, and this is not necessarily a matter of general understanding, but to me, districting is drawing lines. Apportioning is what you give to each district without regard to drawing lines. Now, even if you require single-member districts, you may need to redistrict as population shifts and as population growth occurs unevenly. See what I mean? You will still be districting and reapportioning even though you require all single-member districts, for instance.
Yeah.
You may need to redistrict in
Redistrict.
order to reapportion the body.
Mr. Chairman.
Mr. Fisher?
Yeah, you're the lawyer, Rick, but I don't agree with you.
Okay,
And
good.
really, the redistricting has to do with changing the actual type
Let me
of
give you a
districts.
hypothetical. Suppose
Involved.
you've got two districts, and they're even population, even number of people in them. That's the way you want, even number of representatives.
Right.
That's the way you want it to be.
Right.
5 years later, there's twice as many people in one of them as in the other.
Right.
And you still want to have an equal number of representatives from each. You're going to have to change the lines
That's right.
in order to occur. That's
reapportionment.
No.
That would not be important.
At least, I think it's sufficiently vague that we should make the distinction, because,
And Rick has worked very
well,
lot on it.
Dick and
No,
I...
and if we have to add something, just to make it clear, that doesn't bother me. The trouble with the word redistricting that bothers me is that legally, does that mean you can change the districts? I mean, you can change the...
Well, we would have to make it clear if we wanted to, that even though we're allowing for redistricting, that power shall not include the power to change the
Okay, and if we
form of-
clarify that,
Then, in other words, what you would do, and I think the safe way to do this would be to say, the assembly may be districted, etc., in a manner provided by law,
accept
And
that.
not inconsistent with section 2 umpty on it.
201.
Yeah.
Provided they go with single-man districts, or provided they go with whatever proportion districts we decide.
Well, then you have to say districted, redistrict, actually, what you don't want to say is redistricted or reapportioned.
And redistricted, and/or reapportioned.
Yeah.
Well, you may need the apportion because the first system, that is the first election, may be held on a different basis than the subsequent election.
So you can reapportion without redistricting too. In other words, if you have your two hypothetical districts and 10 years after they're set up, it just happens that there are twice as many people in District 2 as in District 1, well, you just shift one over or whatever.
No, I think that's what, no, I don't think, well, I don't know the sense of this body, but it would seem to me that this body isn't going to call for that.
Oh, I understand. I'm just harping on the distinction between districting and apportioning.
What?
Isn't going to call for the hypothetical that Rick, isn't going to allow a district here, a district there, and the assembly, remember there's 2 elected from this district and 2 from this district, isn't going to allow the assembly to say there'd be 3 from this district and 1 from this district.
You
Regardless
know,
of population.
I think I've got a comment here.
Mary?
I think we're going to have to speak to whether, the first thing in this thing, as to whether we are standing for at large, or single districts, or multiple man districts, or what, and this needs to be the second sentence in the thing, because we're all arguing it, and darn it, if we argue it, the rest of them are going to say, well, what you talking about?
No, but, Mr. Brony, I think that the suggestion to reference this sentence back to the other provision of the charter when we adopted
We
it.
decided we were doing no reference.
No.
Don't like to.
Mary, we decided we wouldn't reference the documents outside of the charter. When they have the charter, you can reference from one to another. It's in their possession. Different.
I think that what we don't want to do is we don't want to send them somewhere else in the charter when we can avoid it.
And this may be a case
And I
where,
think this is a place we can avoid it.
well, Mr. Chairman, I think that, Mary, this is a case where it would be clearer to reference rather than not to reference. Otherwise, we would have to completely spell out the provisions again of that other section. But this is something that when we view the document as a whole, we may wish to make changes. We may wish to move this or switch it around. And we are scheduled tomorrow night to discuss preliminarily our form of districting and our form of mayor-manager.
Lisa?
I'm really confused. In this section, as it's stated right now, we're not setting up any districts or anything, right? We're just leaving everything the way that it is. By stating this.
That's right. We're going to do that in another section.
But I mean how the town, how the people vote. We're saying right here that there's 4 districts, right?
No.
Okay.
Lisa, if I may, in another section, in section 2, this will be addressed what the districting is.
Okay, if we say in there that we want single-member districts plus at large, and then here we say that we will be apportioned and reapportioned in a manner provided by law, and then in another section we will say that we are going to, in the first election, we are going to be, you're going to elect your people by multi-member districts, and then after that, they'll go back a number of years after that, they will go and reapportion so that you'll have single-member people plus at large. That's, you know,
Mr. Joseph?
I think I may have confused you because I mentioned that was a possibility of saying that next October, first election will be on a present multi-member district basis. That hasn't been a decision of the Charter Commission. This language doesn't go to that very important subject
it says, I guess it says that, if it says anything, that whatever system of apportionment is included in the charter and whatever legal requirements there may be under court cases and statutes will govern the assembly in districting, apportioning, and reapportioning. That's really what it says.
I want to miss
Mr. Chairman, Lisa,
Barry?
you've left off the reference to and consistent with the provisions of Section 201. And Section 201 would be the one that would say there shall be 11 single-member districts, or there shall be 4 multi-member districts, or there shall be 4 multi-member districts plus 3 at large, or whatever system we decide on. And so this merely says that then when the population base changes, we will redraw the lines consistent with what we said in 201 and with law.
Okay,
Mr. Chairman, I have a suggestion. I see no reason why this 504 needs to be under elections. I would suggest putting it in after where we talk to the districting.
unless we say there will be these districts.
I just say
we
move
put
it.
a map in there that
Move
says
it.
these are the districts, then why is this here?
That's what I'm suggesting. Let's move it back.
Chairman?
From wherever we're going to have the other.
That's a good suggestion, Bernie. Either that or that we actually have the distribution districts
Here.
in this specific place. I mean,
Either bring them up here or put this back over yonder. I don't care which place you have it, but get them together.
Right.
Joe, you had
I have no problem with that.
Rick, do you have any?
Any legal problem?
Not really, I don't think that's a problem. Of course,
I see nothing that says it has to be here.
no, I probably does fit. There are other, my only comment just sort of in passing is that there are other aspects of reapportionment than just drawing the lines, for instance, the population base, things,
Sure there are.
all those questions.
But as long as we're talking about districts, let's do all of it at once, so that we don't confuse the people that we haven't spoken to it. Get it all together.
Would you have any problem with accepting this wording now with the suggestion that it be combined with the part where we talk about?
It should follow immediately the part where we say we're going to have single-man districts, the part where we say we're going to have
We may
multi-man
have-
districts, or so forth.
We may have to make shufflings around in various places in the charter, and since we've discussed this at great length tonight, could we vote on this particular concept, or would you feel better about doing it along with the other?
Sherry, the thing that bothers me about this is that if this is immediately follows another section, it seems to me that it's going to make some sense in a little different wording. In other words, we could drop districted or apportioned. I think, the trouble is that the two of them do tie together, and that's why the language would kind of bother me. And I would really appreciate it, Rick, if, well, maybe that isn't a problem, but it seems to me that apportionment, reapportionment, has got to be a word of art by now.
Okay, Dick, I can see your point. The Constitution, for instance, does refer to redistricting as well as to reapportioning. And all I'm trying to do is, if those two terms do mean different things legally, to make sure that we are covered as to both of those meanings when we decide what we're doing. Now, I really think if the commission decides what it really wants to do, I can probably work out the language.
Yeah, I don't have any problem with that either. Okay.
I would suggest then that we defer action on this motion until we consider the section on actual districting,
Second.
actual composition of the assembly.
Number 2.
Section,
Second.
section 201.
I don't know, at the moment, we have a motion and a second, which has been discussed for some little time, to eliminate some words in this.
Chairman,
Now we have
I move that this section be referred back to committee for further placement action.
I don't believe we got a motion. Oh, just strike district.
motion. Is there a second to Jim's motion?
Second.
It's been moved and seconded that we refer it back to committee for movement to some other section.
Well,
For rework.
or
For rework.
reconsideration,
Right, that's fine.
because we may want to leave it to section.
How do you want it to read in the minutes? For reworking or
For reconsideration.
is there was a second? That was Parsons and Fisher.
Shy.
Shy? Is there any further discussion? 1, 2, 3, 4, 5, 6. There are 6 here that passed unanimously. Do you wish to wait for the other members?
Well, let's vote on it. I
No,
think we're in
vote.
agreement.
All those in favor?
Aye.
Those opposed?
What am I opposing? What am I opposing or missing?
Sorry, Mary, you missed it.
You can vote no if you want to, Mary.
I don't know whether I want to vote no or yes.
We refer that section back
Going to put this in the
for
most place.
reconsideration.
We referred it back to committee.
For the guidance of the subcommittee and your harassed scrivener, what are we supposed to be doing once we reconsider? In other words, do
I
we
know
have
what we're
any,
supposed to be
I
doing.
think moving it.
do we have guidance from the commission as to what substantively they want to say?
Mr. Chairman? You know, when we find it and figure out what we want to do in terms of apportionment, as a matter of argument, it would seem to me that this ought to be under, the apportionment of the assembly ought to be under elections, this section, in other words, rather than under what Article 2. I think it ought to be under Article 5 rather than Article 2. It just seems to me to read better, but I don't know.
Well, let's
see what happens.
leave it where we sent it and move ahead.
Yeah.
I agree.
And because we're only partway through our agenda tonight. Now I think we move on to Article 2 on the Assembly, with the exception of those portions referring to composition of the body.
Have you got a proposed draft of this also? Oh, come on, why don't you give them all to us at once? This is getting heavy. We're labeling them out.
Feel free, here you go. Your
That's-
services.
Thank you.
That's so that you don't sit here and look at the other ones that are telling you.
No, I think
Service areas are here.
I think I could dog trust myself to that extent.
I think
There you
she's
go.
given you
I
everything.
forgot one.
I need a copy, please.
Uh-oh, I don't like it when they come with staples, you know.
That's all explanation.
Oh, Lord.
Joe, will you make sure I get one of these checks? Yes, sir.
We wouldn't take it.
Can we take a,
I should, I really feel like making a disclaimer of sorts here, in that we have a subcommittee meeting and there's a lot of discussion, and I gather some sort of gist, and I try to put it down hastily in every case, and I don't come in with this thing written in my blood, you understand? The basis for discussion.
it's not a sacred cow.
There you go.
I'm going to go get a candy bar while the rest of you consider what was written for the Assembly, not service. Service areas will not be done tonight.
Who's got a nickel for 5 pennies?
And it was after this version
I'll probably...
in the subcommittee that I came up with mine that I gave you at the beginning of the evening. If that's of any interest to you. I wasn't happy with where we had gotten on this, and I worked all day on it today. I like that 203, because that gets around the business where one assemblyman gets paid differently from another.
Let's get it read through so everybody knows.
Yes.
We really argue that we want to be
Okay, all right. Debbie, I'm glad you mentioned that, because my secretary did not get to the finance stuff today, which I hope to do, and I present it to you here with me. That's Title 8 and 9, related to finance and taxation. That's right, I don't know about finance and tax. Right. And what I'll do is just check with you when you're finished, so I can review.
financing what?
Taxation. I believe it's Article 8.
Because I feel a little guilty about her doing that.
Oh, okay, well, it's not, no sweat, I'm glad you're geared up and what I'll do
And I
is,
think it would be more helpful for the commissioners if we do this on a regular basis.
You bet. I can deal with you by telephone as to changes and stuff. I don't have to run over there. Well, I mean, don't worry about that, I'll be at your office.
Well,
I'll be at your office.
would the commission like to have me go through these things? Or would you like to get to them one by one?
Sure, I think it'd be good for you to go through and review the whole thing for us as seen, as you've, as the subcommittee ran, and then we'll come back and start comments. Any objection to that procedure from the commission? None? Please go ahead.
Sections 201 and 202 are postponed until after we have a discussion on the form of executive and the form of districting. Section 203 on compensation, we added a sentence here from the Model City Charter because primarily we've heard rumblings over the past few years about people raising their own salaries. And the Model City Charter recommended that increases in compensation not take effect until after certification of the results of the next election, just as a safeguard against assembly persons raising their own salaries.
And in fact, 2/3 of them would be with this, but it avoids the unhappiness of assemblymen being paid different pays.
This is as good as you're going to get, I think.
Now, on determining and filling vacancies, we have shortened C quite considerably. Let me review my notes a second. We've been doing so many, I find it hard to remember.
I have a question about 204 of the attorney, Mr. Kearney. The statement that the assembly shall be removed from, an assemblyman shall be removed from office if he lacks any qualifications prescribed by this charter. I assume that if he lacks any qualifications prescribed by the charter, one option is that he not be seated. Is that right?
Well, I think probably that would refer to the case where the guy moved out of his district, say, in the middle of his term, something of that sort.
Was there a reason, Rick, why you said remove from office rather than forfeit?
No, we thought, I believe, in the subcommittee that it would be cleaner to choose one term or the other, removal or forfeit, because they were pretty closely related.
But I mean, it isn't, we're not coming to the point where if someone runs who is not qualified for the charter, not qualified under the charter for the assembly, that his right to run isn't challenged, but the remedy is the assembly removes him, are we?
I would hope not, no. I mean,
You know what I'm saying?
yeah, it's a
It's not
selection
an exclusive
challenge.
remedy that, in other words, he wouldn't say, well, the assembly is the judge of my qualification.
That's-
But first I am sworn in and then my peers remove me. Is that what he would say?
That's not the intent, Joe, but that raises a whole nother area of problem, as you know, at the state level, and I don't know how our plans deal with that. But the reference here, I say, is just very standard language, which I think generally refers to no longer having the residence requirement, living within your district or whatever. I have a joke too. Well, I'm just thinking about the same problem that he's raising, and I assume that it would still be open for a citizen, or we can provide for it anyway, to challenge the qualifications of a candidate. It's open for the clerk to refuse to enter on the ballot the name of a person who doesn't meet the qualifications, prime petition, that sort of thing. I don't believe this language precludes those traditional approaches.
It may be handled by you.
But I see what you want.
Chairman, there are two things that I'm questioning here. The implication is we are choosing assembly by this wording. Now, if we choose something else, we change it, right?
Change it.
To councilmen or commissioners, if we decide we're going to be called commissioners. That's a stylistic kind of thing. Reading on, it becomes a determination on the second page rather than a stylistic thing. That's one. So that I can live with that partly. A says an assembly seat becomes vacant upon the death, resignation, or removal from office, or expiration, or do we need to say?
It doesn't become vacant upon expiration of the term. There's just no term. In other words, a vacancy exists within a defined term, as I understand just the concept. And when the term expires, you no longer can have a vacancy in that term.
All right.
Let's go back and let Sherry complete the report of this subcommittee work. So
Mr. Chairman, I would think that perhaps since this is such a long document, that we would be better served to go through it and have discussion section by section. Because otherwise, if I just do a review, I'm going to have to re-review each time we get to discussion. So I would suggest that we consider, unless someone has a question right now, that we go through and consider each section.
Great.
So
fine.
why don't we go back to compensation, and I would propose that perhaps we adopt whatever we can as we go. We did discuss this last week, this whole article. We went through it once, if you'll recall, at our last regular commission meeting. And so this is coming back to you, wording what we discussed last week.
It's best I could do that.
Okay, Mr. Chairman.
Fisher?
I don't think the second sentence in the 203 is desirable, first of all. While not being desirable from a mechanical standpoint, because I think that assemblymen undertake, I wonder if it's desirable from the point of view of public relations, which I understand is the purpose for it.
You're talking about, Mr. Fisher, mechanics right now? I mean,
I believe that it's not, I believe that it's desirable to encourage the assembly to raise their salary all the time, because I don't think they're going to do it anyway, and I think they're underpaid, and I think that's one of the major problems. So, as a matter of philosophy, I think that I'd like to encourage that, not discourage it, which we're doing by this wording, and I don't know.
I don't agree with you, Dick, that you're discouraging it, but you're just setting it so that they can do it more sensibly to the public. That makes it easier for them to do it, in my estimation.
You think it does?
Yeah.
I'm wondering if it might be desirable to set up a procedure whereby a personnel board or such like determine the desired salary range.
No, it wouldn't even be necessary to have it be proposed by the mayor and fixed by ordinance. That would help a lot.
No, that's putting the bug on the mayor's back.
Oh, well, he doesn't mind putting the bug on having the bug put on his back for his salary. I mean, for the salary of the assemblyman. He doesn't mind that at all. I wouldn't think. And if he did mind it, so what?
Well, are you saying that the mayor's recommendation would be
Yeah.
a requirement of an increase in pay?
Recommended? No, it'll be recommended by the mayor and fixed by ordinance.
Dick, if I get you right, what you're really saying is that the mayor would institute it and would take the onus of instituting it off the legislative body.
That's right.
I don't.
Joe's question, excuse me.
So, Mr. Chairman, he can do that at his option at any time. I don't think that the charter ought to refer to that as a step, and I don't think the assembly should be prohibited from considering the issue like any other
Okay.
charity.
Mr. Chairman, Dick, the way I view this is that it makes it easier for the assembly to raise their salary in one sense because they can feel greatly magnanimous about the fact that they will raise the salary not of themselves, but
Oh, but they are.
of the body after the next regular election, even though 2/3 of them will still be on the body at that point. And I think it could take away some of the bad press that they might expect if they raise their salaries effective tomorrow.
Well, no, they have the option of doing that anyway. And that's what they do anyway. So, that's...
Oh, of deferring it, yes.
Oh, certainly.
Yeah, but I'm making it,
You're making it mandatory, and I don't know if this is better to just limit it.
Joe?
I guess I'm cynical about this sort of thing. If you confront a 3-year term and you can immediately take effect to a $10 a week raise, you can do that. If you're barred the first year, then you raise it $15 effective the second year. I mean, I don't really know that this accomplishes very much.
Well, Mr. Chairman, I think by having it in there, though, as far as the public's concerned, they see a restriction, which is very acceptable to the public. And it makes the charter saleable, that you've got something in here.
I think
puts a
Fred's got
limitation.
something on that.
It's a practical
Yeah,
consideration.
it's all it is. I mean, you can maneuver this thing 9 ways to Sunday.
I've had folks tell me both ways, that assemblymen should be paid more, and others say that assemblymen should be paid what they're being paid. So,
Oh, I don't think that's the issue here. The issue here, though...
take your choice. I think this is saleable,
Well,
the chair.
the issue here is that, aren't you really trying to kid somebody by putting that in? I mean, really?
am I trying to kid somebody?
Yeah, I mean, are we trying to...
No, it's in the model city charter. It appeared to be a reasonable and, to me, very plausible way of dealing with raising of salaries. I have found in going through the model city charter, comparing it to the 1971 charter, that the 71 charter adheres to the model city charter remarkably. I mean, in many sentences and paragraphs, it is verbatim. It appeared to be a
I think
good
that was the
provision.
basis for it.
probably it was. And it made sense to me, it made sense to the subcommittee, that's why we proposed it.
Remember, that charter's been successful in 2,000 cities.
Well, that charter has,
The model charter, gee,
no,
read the front of it. I'm going to point of reading it.
it's not accepted that way.
You're an
There.
argument bastard, you know that?
Is there a motion?
There is no motion on the floor.
Excuse me.
Chair will entertain a motion.
I move we accept 203 as is.
Second?
Been moved and seconded to accept 203 as it stands, as recommended by the subcommittee. All those in favor?
Aye.
Those opposed? So ordered. Would you go on to section 204?
I would be happy to answer any questions that I can concerning that section.
Well, under B2, would you put, that would be one that says lacks any qualifications or knowingly violates any express prohibition prescribed by this charter? And put the two together.
You're saying, Lisa, that maybe they should be together? Or
This is just a stylistic
It keeps from saying this charter twice. She's right, it does. Lacks any qualifications prescribed by or knowingly violates any express prohibition of this charter.
Rick, do you see any problems?
No, I think you're choosing between repetition of the word charter and a complex sentence, you know. I'm not sure which is preferable from a stylistic point of view. My bias is against complex sentences in a charter, but I don't feel strongly about it.
I don't think it's that convoluted nature. I would feel it'd be a good change.
May I make a suggestion, sir?
Mary?
Lacks any charter qualifications, period.
No.
Why prescribed by this charter? We're only in one charter. Why don't we say just lacks any charter qualification?
Chartered.
I just said charter qualification.
I find the reference vague there, I don't.
As in charter members, you know, I suppose, if you use the word charter as an adjective there for qualification.
If there are qualifications for assemblyman given somewhere, then if he lacks any charter qualification. We're talking about assemblyman.
Grammatically, that's vague to me.
Go back to Lisa's thing. Lacks any qualifications or knowingly violates any express prohibition prescribed in this charter.
That would be,
I like that, so.
That's a
lacks any qualification or
knowingly.
knowingly violates any express prohibition of this charter.
Lacks any qualification of this charter, you can leave it
No.
prescribed by.
Prescribed by this charter, left out.
Yeah, but I'm questioning the leaving out of the prescribed by.
Mr. Chairman, it's getting out of hand, you know. Some poor judge is going to have to figure that out. And I think it might be awful tough.
You mean a judge is that stupid?
Right, what?
Well, I think it sounds pretty good the way it is, frankly. Reverse.
I move to approve 204.
Well,
With any changes?
I'll second it. I'd like to discuss it.
Motion to approve 204 as presented. Any discussion?
Yeah, I'd like to understand something, Mr. Chairman. There's been some language added, 3 becomes physically and mentally incapacitated. Why was that added? Or why is that in there?
Rick,
We copied that from the city charter, didn't we?
you got it in the borough too.
It seems like a good idea, I think.
I think it is.
Although some of them serving are in that situation.
Who's going to make the decision?
Yeah, who does make the decision?
Well, Lisa,
It says here, the assembly by ordinance shall provide determining what
standards.
incapacity is.
Yeah,
Standards for it.
right.
Standards and procedures. There are-
I don't like that. I don't, you know, they might say if you ever went to API that you can't serve on the Borough Assembly.
Well,
They could do anything.
there is a possibility of abuse, but there is a provision like that which relates to judges in our state constitution, and what was done there was a commission on judicial disqualification, which has worked rather well. There have been 2 or 3 instances where one I know of which led to a removal of a judge because of incapacity. But I don't think it's been abused. So if something like that were done, it would.
You're saying that possibly the charter should say that the standards and procedures for determining incapacity should include an independent commission of this sort, or?
No, Mr. Chairman.
Well, the point is, the danger, of course, is that an unpopular person on the Assembly could find himself skewered by this question that his colleagues say you lack mental capacity because you disagree with us. All I'm saying is that there has been a way that's been done under state law. It has been done by independent people, and it's worked out satisfactorily.
One point just on that procedure, we're talking about incapacity as a basis for removal, and we do require that the Assembly adopt provisions for notice, public hearing, and judicial review in the case of removal. So incapacity would fall within those provisions, that degree of safeguarding.
Mr. Chairman, in the city charter, it says a judicial determination that the incumbent is of unsound mind.
Well, and that's a lot narrower than physical.
Yeah, in that case,
You might be physically incapacitated and not mentally.
Sure.
You might
Or
be
like-
you might be a stretcher case, and
You might be mentally incapacitated, but not of unsound mind.
I would prefer the wording
Can you be?
from the
Sure.
city.
Unsound mind. Well, this is expert. What do you say?
Well,
Unsound mind is EOR.
there are 3 things. There's the McNaughton rule, there's the New Hampshire rules, and there's the third one. And this is as close as you're going to get to anything that covers anything in the general nature.
The mental incapacity. Yeah.
And it's a continual dialogue of argument in legal and medical legal circles.
I think unsound mind is more akin to saying, does he know right from wrong? Mental incapacity suggests just a diminishment of a judgment.
Pretty
Well,
broad.
true. We're trying to stay away from insanity concepts. For instance, in the case of a public employee, you can have a mental disability, say through a stroke, which entitles you to disability payments and all this sort of stuff, and still be not
Functioning.
insane. I mean,
functioning
yeah.
functioning adequately still to do a job.
Well, Mr. Chairman,
Mr. Fisher.
what would happen if there wasn't that number 3 in there? Doesn't C really cover it? I mean, can't the Assembly, I don't have any fear of the Assembly if they do something by ordinance, if they take the action. I don't personally have any fear of them turning it around later on. In other words, why can't we leave it to the Assembly to prescribe for what constitutes a vacancy? And which part of that description will be physically or
Listing of things like that, really, because, and it could be covered later.
Yeah, well, that raises another question, too. What is the kind of physical incapacity that would render you unsuitable as long as you made the attendance standards
That's right.
of the Assembly, which are already covered? If you're really you know, if you're physically unable to get there for a prolonged period of time, you may be excused, or you may be counted as absent. I
About
don't
if
know.
you became deaf and dumb, for instance.
If you became deaf and dumb,
Not being authorized.
it might be the
End up
best
with
assembly.
it.
All right.
You wouldn't at least commit any wrongs.
Not seriously.
Mr. Chairman, how would you feel if we were left out?
Yeah.
How would I feel? Well, you see, I didn't put it in the first place.
Or whoever
So I
put it
don't,
in,
in fact,
All right, why don't we, why
I
don't we just...
I don't think the subcommittee really even discussed this in depth,
Okay.
but,
Mr. Chairman?
Do you have any trouble?
Mr. Chairman? Mr. Chairman? I'd move to amend the motion to eliminate 3 and renumber the remainder.
Second.
Eliminate 4?
4 and 5 to 3 and 4.
Mr. Chairman, what does that do to the phrase in number C about standards and procedures for determining incapacity, since incapacity is no longer...
You would have to make that 5 itself.
Well, but if the charter doesn't provide that an assemblyman can be removed for incapacity, why would the assembly be able, by ordinance, to establish standards for incapacity?
if you want C,
you do
you've
have an
got to
expressio
have...
unius problem there, I think. Well, I mean, this implication that by spelling out some reasons for removing a person, that's it, and you can't add on other reasons.
Mr. Shine.
Mr. Chairman, 3 is a common expression, and it's protective to the public. What's wrong in leaving it in there? It protects the public.
Well,
Now, whether it happens or not, the fact is there's a protective device in this charter.
Mr. Chairman?
At the moment, there was...
I'd like to amend that motion to strike also including standards and procedures for determining incapacity. With permission of my second.
There hasn't been a...
Yeah,
Parsons.
that's fine.
I'm sorry, also strike the phrase what?
Including standards and procedures for determining incapacity.
Ms. Froney?
I would like to propose a substitute motion that 204 only consists of C, the assembly by ordinance shall provide for determining the existence of a vacancy and provisions for notice, public hearing, and judicial review in the case of removal from office.
You could leave that other phrase in there too, incapacity.
I All right, the whole business, I would be happy just to go without C as is.
Yeah.
I would be happy just to have the whole business just be C as is, nothing else.
What would you eliminate? You eliminate B? Is that what?
I'd eliminate everything. And
A
this
and
would be-
B.
And this would be A, period.
Okay.
I'll buy
One
that.
technical question on that point is, in this section as a whole, we distinguish between vacancies, that is, a vacancy occurs on death, resignation, or removal. And in C, we're only talking about standards and procedures for removal.
No.
We do not want to refer to death and resignation and so forth.
The assembly by ordinance shall provide for determining the existence of a vacancy, including standards and procedures for determining incapacity and provision for notice, public hearing, and judicial review in the case of removal from office.
Yeah, it's that dangling reference to removal from office that concerns me.
I don't think it's dangling.
Okay.
Mr. Josephson?
Well, let's see.
Was there a second to Mrs. Fromen's
I'll second that motion.
Well, the motion, it would be to strike
Strike A and B.
A and B.
And make C A by its lonesome.
Is that,
Well, I would oppose the motion, Mr. Chairman, because I think
one of the things at least is we have the minimum attendance requirements in, that would go out.
Mr. Josephson, I'd like to speak to that. I think that this minimum attendance thing is a bugaboo, but I have yet to see the chair or any other assemblyman refuse to excuse an absence.
Yeah, it's like
You don't, because the other guy is not going to excuse you if you object. And you just don't. So it has no validity so long as you're going to allow an excused absence at all.
Now, Joe, do you have further comment on it?
Only that if Mr. Fisher's, well, if this motion fails and Mr. Fisher's motion fails, I would offer new language for number 3.
Suggest a new language. You might discuss it. You might find something better.
I would, instead of saying becomes physically or mentally incapacitated, I think it would be more protective to say something like suffers physical or mental incapacity that impairs substantially his ability to serve, because then at least the charter contains some standard as to, it confines the assembly's.
Incapacitated to serve as an assemblyman?
Yes.
Yes, you better, if it's necessary at all.
Yeah, I would prefer that wording, but
It says the same thing, though.
yeah, but I'm trying to see why we need why the substitute motion that Mrs. Froning proposes does not cover enough of the charter, and that the other things can be covered by ordinance.
I'd agree with that.
Mrs. Holmes?
I'm very much in favor of making this as short as possible, and I wonder, I'm just sort of thinking aloud now, the ordinance could provide that if an assembly person is convicted of a felony, they would be removed, and
The city has one. We've got one.
they lack any qualifications.
We've got them in our ordinances. Do you have that copy? I gave you the things that we have.
Is there,
I would suggest that maybe A is an introductory sentence that sort of defines the parameters in the language for us, and that if you considered A and C together, I would be in favor of that, I think, and not having B at all.
That's all right, too.
I would accept that.
Mr. Chairman?
Mr. Fisher?
What is the purpose of B1 and 2 in the first place?
Any qualification prescribed by this charter or knowingly violates any express prohibition of this charter.
I think it's just tradition. It was picked up from past usage, and so on.
Well, what is the, I mean, is it necessary to be in there in the first place?
No, that's what we're doing. We're trying to take it out at this point.
Well, Mr. Chairman, I understand some of these other things and why they're there, and I may disagree with taking them out.
Well, you're the guy that originally started this whole thing.
Well, Mr. Chairman,
Wait a minute, Mr. Chairman, I'm sorry, but I haven't finished sharing. You know, I don't like the idea of just substituting the C at all, because I do want to
Give me a card.
get into missing meetings, missing regular meetings, and the requirement for excused absence. I think that's the very least we can do. But I don't understand why 1 and 2 are there at all.
Mr. Chairman,
Legally.
Mr. Holmes?
I see those as a remedy. I mean, we have said in this charter that there are a lot of no-nos, that you shall not do this, you shall not do that, and we have not said, if you do that, then this will happen to you. This, as I see, is the prison sentence that the person has imposed on him for.
But what is the legal effect of saying that?
the legal effect of having them in
Yeah.
is removal from office if they don't meet those qualifications, or if they violate knowingly a prohibition set forth in the charter elsewhere.
The legal effect is to create the crime of charter violation and to prescribe the penalty therefore, which is removal.
Mr. Chairman?
Which wouldn't be the case otherwise, right?
Right.
That's your,
We have eliminated other things that we expect would be covered by ordinance on the same logic, unless there is some reason for keeping them in. I would argue strongly for cutting out B.
I would like to back up and say that A is prescribing for the assembly the existence of a vacancy. And therefore, I would go back to saying just C.
there's a substitute motion from Lisa.
Can I say, this is Ronnie's motion, but the assembly by ordinance shall provide for determining the existence of a vacancy and something about removal from
And
office.
grounds for removal.
Yeah.
Because there is a distinction between the automatic effect of death and resignation in creating a vacancy and the removal from office following procedures.
Understand?
I'm very uncomfortable with this, Mr. Chairman. I really am.
I am too, and I am trying to think of a hypothetical case, but I could see that the assembly might not choose to say that if one of their members violated the charter, he would have to be removed from office. They might decide in their ordinance, or they could decide in their ordinance, that it would take 3 violations of the charter. I mean, that's perhaps somewhat absurd, or that a violation of the charter could be excused by a vote of the majority of the body. And they,
Well,
May I have a suggestion here? If you want to use that as a penalty for violating the charter, why don't we put this in the general provisions rather than right here?
Going to what Mrs. Holmes has just said, of course, that's rather traditional in bodies, and I'm not sure that's wrong. Perhaps in a given case, a censure or a reprimand would be the appropriate penalty and not removal from office.
well, Mr. Chairman, could I try a substitute and yeah, see if it flies?
I don't think parliamentary-wise you can substitute to a substitute without disposing of the substitute
This
listed
is
on the
about the
floor.
word substitute.
Well, all right.
But you can state what you would
Okay,
offer. if it was-
Mr. Chairman, I'll tell you, let me state what I would offer. What I would offer is basically the 71 language up to a point of the third sentence down in C, forfeiture. And that's exactly what we've got here. It seems to me it states it clearer and a little briefer than this does. So if we get out the 71 charter, read 204, just as it reads all the way down to the end of the third line there, under forfeiture, removal or forfeiture, period, right to there. It seems to me that takes care of 204 as it's written here. It takes care of it briefly, a little more briefly, and concisely. I don't know.
You would propose that it therefore say 3 consecutive regular meetings rather than...
Oh, yeah, and I like, that's, of course, I like that provision. Rather than having them prescribe it, because I don't think they're going to be that tough.
We went over that time before and said we changed a few words there to instead of the office, an elective office shall become vacant, and we struck assemblyman and used elected official.
Yeah, we're
did do that, and I'm confused because we're back to this reference to the assembly again.
Well, I think this is merely, again, format, if I'm not mistaken, Rick, using assembly, you just used the word to indicate the body.
You gotta pick a word.
Whether it be council or assembly or
Well,
whatever.
I think you're referring
We
to
could have
the mayor.
said the legislative seat if you wanted to.
Well, how about the mayor, though, aren't you? Didn't you mean to include that?
I'm not sure what you're talking about.
Did you?
We came back to the question of using assembly, using the word assembly.
Oh, instead of the elected body or whatever?
Elected official.
Yeah, in the subcommittee, I think we just decided for the purpose of working out the mechanics of the thing, we would use one name or the other and decide later whether we were going to try to make all these things with respect to vacancies and so forth applicable to all bodies or applicable by reference or some other mechanical thing.
We got kind of bogged down in trying to decide whether, when we say elected official, do we mean that the mayor is going to forfeit his office if he misses 3 consecutive meetings?
Yeah.
Yeah.
I have to go because I have to go back into a hearing early tomorrow morning. I hate to leave at this stage of the game.
Will we see you tomorrow night?
Yes, by all means. Do we have anything for tomorrow noon? Or tomorrow night here then, same time? What will we be doing so
I
that...
would suggest that we will be finishing Article 2, because we're not going to finish it tonight, and we will be discussing the form of government tomorrow. And if we have time, we'll be discussing the finance articles.
Fine, with the little activity, we'll have a bad type of the finance and taxation articles as gone over by the subcommittee. Look at that.
To get our,
All right, thank you, Rick.
to get at our parliamentary position at the moment, we have a substitute motion still in front of us, which has never been voted on or otherwise disposed of. So that substitute motion struck everything from of A and B and left only C. Which became A.
Mr. Chairman, I think I have lit upon something that would make it less awkward. May I read it as I would propose? The Assembly by ordinance shall provide for determining the existence of a vacancy, including standards and procedures for determining incapacity, and in cases of removal from office, provisions for notice, public hearing, and judicial review.
Could you read that again?
Yeah. The idea is to get that in case of removal from office, up higher in it so that you know what the rest of that sentence is referring to. The Assembly by ordinance shall provide for determining the existence of a vacancy, including standards and procedures for determining incapacity, and in the case of removal from office, provision for notice, public hearings, and judicial review. That makes it more understandable sentence.
Now, that is a
So
substitute motion.
I would like that to be, if it's agreeable with my second.
I second
If there's no further discussion, Chair will entertain a call for the question.
Question.
All those in favor?
Aye.
Those opposed?
Aye.
The opposed are Mrs. Holmes, Mr. Fisher,
I'll call for roll call vote on this question.
and myself. Those in favor were Crony, Chai, Parker, Josephson, and Parsons. The motion has failed, 5-3.
Then I guess we need to leave it until we've got a larger quorum to decide it.
We have, we go back to amendment to the motion, which I'll ask the secretary if she can find the amendment.
Well, Mr. Chairman, let me Jim, that seconded it? Could I?
Yes.
I would like to, just to withdraw that.
Agreed. I forgot what it was.
Yeah, and I would like the opportunity to substitute the 204 as written, as previously written, up to the point of forfeiture. Separating as this section does the filling vacancies. I'm in trouble with that. I can read the entire language if you'd like me to.
Dick, you're going back to section 204 in the 71 charter.
Right.
Down
And
to
as
the
an entire substitution for this entire section 204.
through C in the 71 charter, third line, and
Yeah.
the word forfeiture.
Right.
Eliminating vacancies shall be filled, etc.
Right, and that's dealing with the vacancies separately, which the subcommittee apparently wanted to do, which is fine. I don't see any problem with that. This
is Mr. Fisher's motion. Is there a second?
I second the motion.
Mr. Josephson seconded. Is there any further discussion?
Can we have a moment to compare the two?
Yeah.
It's sure wordy.
Yes, it is.
Well, is it really much more wordy than 204 as presented was?
No, it's less wordy.
No, it's not much more wordy than 204 is presented, but that's the problem I see with it.
This addresses apparently a definite number of meetings.
Yes, Mr. Chairman.
I could support this motion, except I still have this question about what happens when you have some guy who's completely incapable, mentally incapable of holding the office. I mean, to the point of, I mean, there are cases like that. And what would the body do, or could the body do in that case to ensure that the public is protected and has a representative?
Dick, your
on the
motion went
commission,
down.
especially if it's a single, especially if you go to single.
We're going to have to go
Member
back to our
District C.
attorney in residence to find
Third
out.
line.
Mr. Josephson?
After forfeiture in the third line.
It's a good question. I think you have to sort of take,
Okay.
the only way I can answer that is to say you take risk for risk. You know, on that end of the spectrum, the risk you're concerned about is the lunatic who, because of trauma or something, cannot represent a district effectively. What do you do about him? Of course, if he's disruptive, there are remedies to remove him from the room or whatever else one has to do. But the other side of the coin is the other risk of someone who really has capability of serving, but, you know, in a way is railroaded. I mean, that's the other side of the coin. I don't know that there's any satisfactory solution to it. That's why I tried to offer language where you at least put in a more objective standard of you know, for example, physical incapacity may, in most cases, I still think will have nothing to do with your ability. You could be brought into a stretcher flat on your back, and as long as you can reach a button, you know, and follow what's going on, you can serve effectively.
The inequity that I see in this is that if this mental incapacity occurs to the representative at the beginning of a 3-year term, and there is no way to remove that person from office, that seat is taken up by someone not representing his constituency for 3 years, whereas you're worried about the body railroading and removing someone, and if that happened, the people would within 30 days or 60 days or whatever, have a chance to re-elect someone to represent them. So while an injustice might be done to that one person, it would not be done to the people he's representing. And I see the greater injustice as an injustice to the people who are being represented.
Chairman, can't they petition to have that person removed though? People want him removed and feel he should be?
Recall, I suppose that would be a thing, yeah.
Well, Mr. Chairman,
Mr. Parsons?
I find myself maintaining the position on the motion that lost, and I will therefore vote no on this one. I don't know where we're going to get.
Well, why don't we call for the question on this one and...
Well, Mr. Chairman, let me say this. This motion could be adopted, and a motion to add suitable language on the point Mrs. Holmes raised could be made to it, as I understand it.
And that's getting even more wordy, which is the part that I'm objecting to.
Well, I'm only saying that the incapacity question needs to be addressed and still be done.
Well, so I had not considered the recall thing. It just hadn't come into my mind. And so since that is a remedy that exists to the voters to remove their assembly person, I think there is protection there. I'd hate to have to take the person to court to have the person removed from office.
Is there any further discussion? Chair will entertain the call for a question. Question's been called. All those in favor?
Aye.
Those opposed?
Opposed.
Aye. Mrs. Holmes?
Aye.
Mr. Parsons?
No.
Mr. Josephson?
Aye.
Ms. Parker?
Aye.
Mr. Fisher?
Aye.
Mr. Schott?
Nay.
Mrs. Froney?
No.
Myself, no.
So here we are. I would suggest, Mr. Chairman, that at this point, that since the hour is almost 10:30, that we postpone further consideration of this section until tomorrow night, at which time we all will have a bit of distance from the thing and be able to perhaps cope a little bit better.
I would so move.
And if I might just recap where we stand for tomorrow night. We will, first thing on the agenda, finish up Article 2. And if you would have a chance to go over this wording before tomorrow night and mark it up however you see fit, that might speed things up a bit. Then we will have a discussion of the form of government tomorrow night. And I will provide you with some preliminary figures. I have only one copy tonight with me, and you may take a look before you go if you want. I'm sorry I didn't have a chance to make more copies for you. The Rowans have gone through the survey, and on the two questions relating to the districting of representatives and the executives that we would have, they have pulled out the results. And those are the two things we'll be considering tomorrow night. A preliminary discussion of which forms we wish. If you'd like to look at those numbers, they're quite interesting.
What does it boil down to?
Of the
Form of
mayor,
government.
manager, the form of government, and districting, or based on the assembly. Well, based on everything we have, the survey, the public opinion poll, so forth. So that's where we stand for tomorrow night.
You were also,
In the finance articles, if we have time.
Single member.
You've got all of this set out for you if you look at your schedule and combine Wednesday and Thursday and take whatever we didn't do tonight.
All right, thank you, Sherry. Are there any persons to be heard who are not on the agenda? Peters? Certainly, certainly glad to have you here. Appreciate it. Any commission member comments? Mr. Parsons?
Mr. Chairman, I would like to express an appreciation for the Charter Subcommittee Production Committee. I know that they have longer hours than we do, and I appreciate the ability.
Thank you.
Thank you very much. It is a labor of love to speak before, I can tell you.
If anyone has a specific opinion on how they would like their name to appear on the Charter Commission stationery, that is informally, such as Dick Fisher versus Richard W. Fisher, as an example. I like your input tonight.
Dick Fisher, the way I ran. Do you have neon?
How about 3 stars versus 4?
You don't want Ferdinand on your chart?
No middle.
No middle, just Lisa.
Just the.
Well, it depends, are we all going to be running for the assembly? I mean,
According to our critics.
yeah, I mean, this is fairly well established.
Tomorrow night, this room, 7:30.
Right.
Thank you for coming, gentlemen.
Thank you all.
Ladies.
Thank you for having us.
You're reminded that there are drawers in the Charter